Good evening to all the distinguished members of the bar, respected dignitaries, learned senior advocates, esteemed colleagues, and dear participants. We have assembled here today to deliberate on the important theme of maritime claims and Admiralty of jurisdiction, the Admiralty Act 2017. Now, I request Mr. R. Venkatesan, the Secretary of Madurai Bar Association, to provide welcome address.
அனைவருக்கும் மாலை வணக்கம். மதுரை வழக்கறிஞர்கள் சங்கம் உயர்நீதிமன்ற கிளையின் சார்பாகவும் குஜராத் மெரைடைம் யூனிவர்சிட்டியின் இணைந்து நடத்தும் இந்த முக்கியமான நிகழ்வான கருத்தரங்கிற்கு வருகின்றிருக்கின்ற உங்கள் அனைவரையும் முதல்கண் வரவேற்பதில் மெத்த மகிழ்ச்சி அடைகின்றேன். வானமாய் விரிந்து வனமாய் விளைந்து கானமாய் திரிந்து ஞானமாய் சுரந்த உயர்ந்த தமிழால் உள்ளம் நிறைந்த தமிழால் அவையோரை வணங்கி இந்த நிகழ்வில் ஒரு முக்கியமான அம்சம் என்னவென்றால், குஜராத் மெரைடைம் யூனிவர்சிட்டி என்று நம்மளுடன் தூரம் கடந்து இருந்தாலும் இங்கே வருகை தந்து சிறப்பித்துக் கொண்டிருக்கின்ற அனைத்து சிறப்பு விருந்தினர்கள் அனைவருமே, குறிப்பாக நமது சீஃப் கெஸ்ட் இன்றைக்கு வருகை தந்திருக்கின்ற நம்முடைய முன்னாள் உயர்நீதிமன்றத்தின் தலைமை நீதிபதி மிகவும் நன்கு தமிழ் அறிந்தவர், தெரிந்தவர். தமிழில் அவர் உரையாற்றுவதற்கு அவருக்கு ஆவலாத இன்பம், தமிழ் மீது அளவிருந்த பற்றையும் பாசமும் கொண்டவர். ஆகையால் நான் இந்த வரவேற்பு உரையை தமிழில் சொல்வதற்கு எனக்கு வாய்ப்பு வழங்கிய எங்களுடைய சங்கத்திற்கு நான் முதற்கொண்டு நன்றி இருந்த வணக்கத்தை உரித்தாக்கிக் கொள்கிறேன். இந்த அருமையான நிகழ்வு மதுரை வழக்கறிஞர் சங்கம் மாண்புமிகு நீதியரசர் இங்கே பணியாற்றி கொண்டிருக்கிற காலத்திலே தெரியும். இந்த சங்கமானது இங்கே உள்ள இளம் வழக்கறிஞர்களுக்கு தொடர்ந்து சிவில் ஜட்ஜி எக்ஸாம்களுக்கெல்லாம் தொடர்ந்து நாங்கள் எல்லாம் அவர்களை நீதிபதிகளை உயர்த்துவதற்காக பல முயற்சிகள் மேற்கொண்டு இதுவரை 28 சிவில் நீதிபதிகளை இந்த மதுரை வழக்கறிஞர் சங்கம் இங்கே உருவாக்கி தமிழ்நாடு முழுவதும் அங்காங்கே அவர்களுடைய செவ்வன தன் பணியை செய்து வருகிறார்கள். அதனை தொடர்ந்து ஒவ்வொரு வார இறுதியிலும் வீக்கெண்ட் கிளாஸ் என்று சொல்லக்கூடிய அளவிலே தொடர்ந்து இளம் வழக்கறிஞர்களுக்கான வகுப்புகளை தொடர்ந்து நடத்தி கொண்டிருக்கின்றோம். நாளை சனிக்கிழமை கூட நம்மளுடைய மாண்புமிகு நீதியரசர் பி பாலாஜி அவர்கள் ரெண்ட் கண்ட்ரோல் பற்றியான லெக்சரை நாளை காலை 10 மணி முதல் 1 மணி வரை தர இருக்கிறார். இதை நான் இங்கே ஏன் பெருமையுடன் சொல்ல கடமைப்பட்டிருக்கிறேன் என்றால், இந்த நிகழ்வானது இந்த மெரைடைம் சம்பந்தப்பட்ட விஷயங்களை சீரியஸை பேசும் பொழுது இங்கே 4 சங்கங்கள் இருந்தாலும் 4 சங்கங்களில் இருக்கின்ற நிர்வாகிகள் அனைவரும் அருமை சகோதரர் தலைமை செயலாளர் சரவணகுமார் உட்பட நமது செல்லப்பாண்டி உட்பட என்ன சொன்னார்கள் என்றால், நீங்கள் இந்த பணியை செவ்வன செய்து கொண்டிருக்கிறீர்கள், இளம் வழக்கறிஞர்களுக்கான பயிற்சி வகுப்புகள் நடத்தி கொண்டிருக்கிறீர்கள், இந்த நிகழ்வை நீங்கள் செய்தால்தான் சிறப்பாக இருக்கும் என்று இந்த நிகழ்வை எங்களுக்கு அவர்கள் அனுமதி கொடுத்து செய்ய உத்தரவிட்டிருந்தார்கள். அதன் அடிப்படையிலே அந்த அனைவருக்கும் நாங்கள் இந்த நேரத்தில் நன்றி சொல்ல கடமைப்பட்டிருக்கின்றோம். தொடர்ந்து இது போன்ற நிகழ்வுகள் இங்கே நடைபெற்றுக் கொண்டுதான் இருக்கும். அந்த நிகழ்வுக்கெல்லாம் எங்களுடைய மாண்புமிகு நிர்வாக நீதிபதி அவர்கள் நாங்கள் எப்பொழுதெல்லாம் இந்த மாதிரியான நிகழ்வுக்கு நாங்கள் அவரை அழைக்கின்றோமோ அனைத்துக்கும் அவர் வந்து இந்த இடத்தை இங்கே சிறப்பித்துக் கொடுப்பார். அந்த வகையிலே இன்று இங்கே வருகை தந்திருக்கின்ற மாண்புமிகு நிர்வாக நீதிபதி திரு சதீஷ்குமார் அவர்களை வருக வருக என்று அன்போடு வரவேற்பதில் மிக்க மகிழ்ச்சி அடைகின்றோம். இன்றைய தினம் 2 லெக்சர் சீரியஸ் நடக்க இருக்கிறது. அதில் முதல் நம்மளுடைய மாண்புமிகு நீதியரசர் நம் நெஞ்சமெல்லாம் நிறைந்த முன்னாள் உயர்நீதிமன்ற தலைமை நீதியரசர் திரு ஸ்ரீராம் அவர்கள் நடத்தியிருக்கிறார்கள். அவர்களையும் வருக வருக என்று அன்போடு வரவேற்பதில் மகிழ்ச்சி அடைகிறோம். சாந்தகுமார் சாரை பற்றி 2000 அரசு சட்டக்கல்லூரியில் படித்த மாணவர்களுக்கு எல்லாத்துக்கும் தெரியும். ஒரு வைப்ரண்ட் மேன், மிகவும் எளிதில் அவரை வந்து ஈஸியா வந்து அவரை அப்ரோச் பண்ணிடலாம். அவ்வாறான ஒரு பெரிய மனிதரை இன்று நாம் இங்கே வருகை தந்திருக்கின்றோம். இதற்கெல்லாம் நாம் அனைத்து சங்கங்கள் சார்பாகவும் நமது சங்கங்கள் சார்பாகவும் அவரையும் நாம் வருக வருக என்று அன்போடு வரவேற்பதில் மகிழ்ச்சி அடைகின்றோம். மாண்புமிகு நீதியரசரோடு வருகை தந்திருக்கின்ற அம்மா அவர்களையும் வருக வருக என்று வரவேற்பதில் மிக்க மகிழ்ச்சி அடைகின்றோம். தொடர்ந்து இந்த நிகழ்வு இங்கு நடக்கும். இந்த நிகழ்வுக்கெல்லாம் நீங்கள் எல்லாம் முழு ஆதரவு தர வேண்டும். நம்மளுடைய சாந்தகுமார் சொன்னது போல நிறைய நிகழ்வுகள் நம்ம நடத்த இருக்கிறோம். நம்மளும் குஜராத் மெரிடைம் யூனிவர்சிட்டியும் சேர்ந்து தொடர்ந்து பல நிகழ்வுகள் நடத்த இருக்கிறோம். அந்த நிகழ்வுக்கெல்லாம் நீங்கள் முழு ஒத்துழைப்பு கொடுத்து இளம் வழக்கறிஞர்கள் எல்லாம் கலந்து கொண்டு இந்த விழாவினை சிறப்பிக்க வேண்டும் என்று அன்போடு கேட்டுக்கொண்டு பேச வாய்ப்பளித்தமைக்கு நன்றி கூறி விடைபெறுகிறேன். நன்றி, வணக்கம், ஜெய்ஹிந்த்.
Thank you, sir. Now it's time for honoring the guest. Now I request Mr. S. Magesh Babu sir, Vice President of the Madurai Bar Association, to adorn the shawl to Honorable Justice N. Sadish Kumar J. And memento will be presented by the Executive Committee member, Mr. Daniel Dinagaran. May I request R. Venkatesan, Secretary of Madurai Bar Association, to adorn shawl to the Honorable Justice K.R. Sriram, and memento will be presented by Mr. Saravana Kumar, Secretary of the MBA Bar Association. I request Mr. G. Raja, Treasurer of Madurai Bar Association, to adorn shawl to Professor Dr. Shantakumar, and memento will be presented by Mr. R. Alagamani, Advocate. Now the honor will be on behalf of the Gujarat Maritime University. I request Professor Dr. Shantakumar to give memento and adorn shawl to Justice K.R. Sriram and Honorable Justice N. Sadish Kumar J. Now I request Mr. Abhay Singh, Professor, to give memento and shawl to the I request Mr. Abhay Singh to give memento to the Secretary of the Madurai Bar Association, Mr. R. Venkatesan will receive. And I request Mr. Abhay Singh to give a memento to Vice President, Mr. Magesh Babu. Honorable Mr. N. Sadish Kumar J., Administrative Judge of Madras High Court and Madurai Bench. We all of us know today, the day after tomorrow, there will be a building opening ceremony at Madurai District Court campus. He is having full of work on that. Despite that, he grant time for this program and ascended to give inaugural address. His Lordship has delivered several landmark judgments, particularly in the field of environmental protection through the Green Bench. Notable judgments among them matters relating to elephant corridor and preservation of hill stations. His judgments also contributed significantly to reforms in criminal jurisprudence, including several orders granted advancing victim compensation. Now I request His Lordship to deliver the inaugural address.
Very good evening, the President and the Secretary and the members of the MBA, Honorable Chief K. Sriram, expert in maritime law and Admiralty. For us, we always call us the Chief. And Professor Santakumar and members of the bar present here, very good evening. First of all, I congratulate the MBA for organizing the joint workshop on maritime claims and Admiralty jurisdiction of the High Courts under the Admiralty jurisdiction and settlement of Maritime Claims Act 2017. The joint workshop is a chosen the very good experts in the field. The expert in the country, I can say that one of our former chief is an expert in that field. The right person has been chosen to address the workshop. This is the subject, a new subject, particularly the new act, Settlement of Maritime Claims Act 2017, is a recent origin. This act is a comparatively recent but long pending enactment which consolidated the Admiralty law in India. So thanks to this organization, just for giving me an opportunity to present here, to lay my hands, to know the legislative history of this act. So prior to this act, the Admiralty jurisdiction of the Chartered High Courts in India was regulated by Class 32 and 33 of the Letters Patent, which was read along with the Admiralty Courts Act 1961, which was an act of British Parliament. Then came the Colonial Courts of Admiralty, Indian Act 1891, under which 3 chartered high courts, namely Calcutta, Madras and Bombay, were declared as the colonial courts of Admiralty under the said act, along with the High Court of Rangoon in Burma and the district courts of Karachi and Aden in Africa, which was at that time under the Bombay Presidency. By virtue of the said act, the High Court was authorized to exercise the same jurisdiction which was exercised by the High Court of England. So on account of decision of Privy Council in 1926, an interpretation was given to the act which had the unfortunate effect of freezing the jurisdiction of the Indian courts, Indian High Courts, to the jurisdiction which was exercised by the English court in 1890. Thus, even as late as in 1983, the Bombay High Court in M.V. Nico's case took the view that the jurisdiction of the High Court on the Admiralty side was the same as the English courts in 1890, despite the fact that jurisdiction of the English court in the UK had expanded many times since then. As a matter of fact, the English law which applied in 1890 had been repealed in 1925. However, our Indian courts persisted holding that they are bound by the decision of the Privy Council. So this was the position till 1992. After 1992, the law went under the sea change, underwent a sea change in view of the judgment of the Apex Court in N.V. Elizabeth case, reported in 1993, 2 SEC Supplementary 433, wherein the Supreme Court has declared that old interpretation to be a colonial relic and declared that the jurisdiction and powers of the Indian High Court was unlimited, subject only to the provision of the Constitution. So both the learned judges, the Honorable Justice Thoman and Justice Sahai, made a recommendation to the Law Commission to take up the study and recommend a fresh law for the country. Though the Law Commission submitted its report in 1994, it took a Parliament another 23 years to enact a new law. What is the most important change under the new Act? Section 17 of the 2017 Act, which repeals the application of all the earlier British laws and also repeals the Colonial Courts of Admiralty Indian Act 1891. Importantly, Class 32 and 33 of Letters Patent of the Chartered High Courts have also been repealed. The jurisdiction of the High Court on an Admiralty side is now statutory in nature and governed by the Act of 2017. Therefore, one cannot blindly read now N.V. Elizabeth case 1993 to SEC, which was essentially a stopgap arrangement till new law was put in place. Therefore, it is extremely important for the bar and bench to grasp and understand the implication of the new legislation. So, till now, we are not exposed to the new legislation. Only a few are practicing in that Admiralty side. Even the High Court also, only a few of them are practicing this area and other parts. This law is actually totally new, even for us also. But for the opportunity given to me, even I would not have had hands on this to know what is the legislative scope also. So for this purpose, our speaker for the evening is our former Chief Justice, Sri K. Sriram, who does not require any introduction at all to the bar and bench in the state of Tamil Nadu. Justice Sriram is widely acknowledged expert in Admiralty and Maritime law, which he learnt and assimilated from the chambers of his late senior Sri S. Venkatesan, a senior advocate and Dean of the Bombay Bar, who was himself a widely acknowledged expert in the field of commercial law. Justice Sriram had a wide-ranging commercial practice in Bombay High Court before his elevation to the bench in June 2013. In his later stint, he headed the tax division bench in the Bombay High Court for a number of years. Then he was elevated as Chief Justice of Madras High Court in September 2024. He presided over the tax bench and the commercial appellate division during his tenure here. Then later he was transferred as the Chief Justice of Rajasthan High Court, we all know that, and finally demitted office in September 2025. Now he is a much sought after arbitrator in commercial arbitrators across the country and abroad. Even yesterday when we were chatting, we were all surprised how is when expertise has been used, even for just an opinion. He has been, there was a queue. No, there will not be divulged. There was a queue for getting his opinion in the particular field. That's what his expertise. So he was for many years the Admiralty bench on the original side of the Bombay High Court, where he delivered several landmarks decisions which are today the leading cases widely cited in before all courts. Even as recently as in June 2006, his decision in Greenwich Meridian versus MUR Shipping BV, which lucidly explains the concept of in rem and in personam and what constitutes a maritime claim, was relied on by. This judgment is also relied on by our Justice Anand Venkatesh in Ramnath and Company versus M. Stadl on 2026 MHC 67 to interpret the provisions of Section 4 of the 2017 Act, which defines a maritime claim. His Lordship landmark decision in Bargay Madhwa versus Raj Shipping in 2020 saw two interim jurisdiction, Admiralty and Company law, face to face against each other. His Lordship has held to able to balance the rights of all the stakeholders, has held that leave of the Company Court or NCLT is not necessary before instituting an Admiralty suit Act, and held that provisions of Section 10 of the Admiralty Act would prevail over the provisions of the Companies Act 1956. This decision quickly became a masterpiece and had the unique distinction of being reported in Lloyd's law reports. So His Lordship Admiralty law is to Admiralty law what good old HME was to gramophone records. Now let us therefore now hear the discourse on the new Admiralty Act from his master's voice. So I can say that you are all fortunate to have such an expert speaker among you. Take an opportunity to grab the situation. At least this is a learning process. Every day you should learn. Is the experience you have to get from the learning experience from such experts. So you utilize this occasion. But one thing I can say, I am very sorry to say that when such an expert is a Chief Justice of two big high courts has consented to be present here, but unfortunately, once again I thank the organizer for giving an opportunity.
Thank you, Lordship, for your brief introduction and the history of the case laws in the field of maritime laws. Now I request Ms. Devi Sarvanapriya to adorn a shawl to Madam Usha Sriram to honor. Professor Santakumar hardly requires a formal introduction. Many of us here know him as a respected, distinguished professor who served at our Madurai Law College. He was instrumental to establishing the moot court hall in our government law college for the first time in Tamil Nadu. Many many law students benefited from that, and now they are as an advocate as well as they are as the judicial officers and public prosecutors. In 2004, he moved on to serve the Premier National Law University HNLU, and now he holds a distinguished position of Director of Gujarat National Law University, and he is also associate with Maritime Legal University, Gujarat Maritime University. He has been great source of inspiration to countless law students in his whole journey. It is indeed great privilege to have him with us today. I now request Professor Dr. Shantakumar to deliver the introductory address on the Admiralty claims and Admiralty jurisdiction.
மாண்புமிகு சென்னை உயர்நீதிமன்றத்தின் முன்னாள் தலைமை நீதியரசர், ராஜஸ்தான் நீதிமன்றத்தின் உச்ச நீதிமன்றத்தின் தலைமை நீதியரசர், மாண்புமிகு நீதியரசர் K.R. ஸ்ரீராம் அவர்களே, இந்த விழாவை நடத்தி கொண்டிருக்கும் மதுரை பார் அசோசியேஷனின் தலைவர் திரு M.K. சுரேஷ் அவர்களே, துணைத் தலைவர் மகேஷ் பாபு அவர்களே, செயலாளர் வெங்கடேசன் அவர்களே, பொருளாளர் ஜி ராஜா அவர்களே, இசி மெம்பர்ஸ் மிஸ்டர் டேனியல் தினகரன் அவர்களே, மிஸ்டர் அழகுமணி அவர்களே, என்னுடைய மாணவர்கள் செல்லப்பாண்டியன் கருணாநிதி அவர்களே, திருமதி உஷா ஸ்ரீராம் அவர்களே, my colleague from Gujarat Maritime University, Dr. Abhay Singh, உங்கள் அனைவருக்கும் எனது முதற்கண் வணக்கத்தை தெரிவித்துக் கொள்கிறேன். நீதியரசர் சதீஷ்குமார் சொன்ன மாதிரி இந்த சப்ஜெக்ட் அட்மிரல்டி லா மட்டும் நமக்கு புதுசு இல்லை. பொதுவாகவே பார்த்தீங்கன்னா, if you look at the planet Earth, almost 75% of the Earth is covered by oceans. இல்லைங்களா? பட் நமக்கு அந்த அளவுக்கு தெரியுமா? நமக்கு நிலத்தை பற்றி தெரிகிற அளவுக்கு நாலேஜ் நமக்கு கடலை பற்றி இல்லை. We don't have that kind of knowledge about the oceans. இப்போ யுனைடெட் நேஷன்ஸ் கன்வென்ஷன் ஆன் லா ஆஃப் த சீ எல்லாரும் இன்டர்நேஷ்னலில் படிச்சிருப்பீங்க இல்லையா? யூஎன் கன்வென்ஷன். அதை இந்தியாவில் இம்ப்ளிமெண்ட் பண்ணுறதுக்கு ஒரு லெஜிஸ்லேஷன் இருக்குது. இட்ஸ் கால் தி மேரிடைம் ஜோன்ஸ் ஆக்ட். அந்த மேரிடைம் ஜோன்ஸ் ஆக்ட் படி கடலில் நம்ம நாட்டுக்கு எந்தெந்த பகுதி மேலே எவ்வளவு தூரத்திற்கு என்ன விதமான உரிமை நம்ம இந்திய அரசாங்கத்திற்கு நமக்கு என்ன உரிமைகள் இருக்கு அப்படின்றது. அதாவது ஒரு லேண்டில் இப்போ மதுரையில் எந்த அளவுக்கு ஒரு சாவரின் ரைட்டை ஸ்டேட் எக்ஸசைஸ் பண்ண முடியுமோ அதே சிமிலர் சாவரின் ரைட்ஸ் கேன் பி எக்ஸசைஸ்ட் அப் டு 12 nautical miles ஃப்ரம் தி பேஸ் லைன் ஆஃப் தி கோஸ்ட். 12 nautical mile, ஒரு நாட்டிக்கல் மைலுங்கிறது 1.85 கிலோமீட்டர்ஸ் தூரம். அப்போ 12 nautical mile வரைக்கும் நமக்கு சொந்தமான கடல், நமக்கே சொந்தமான கடல். நம்ம கோஸ்ட் லைன்லேருந்து 12 nautical miles. 12 nautical mileனா அப்படி ரஃபாக கால்குலேட் பண்ணிங்கன்னா ப்ரிசைஸ்லி ஆல்சோ இட் வில் பி 22.224 கிலோமீட்டர்ஸ். இது ஏன் இந்த கிலோமீட்டர்ஸ் ரொம்ப இம்பார்ட்டன்ட் அப்படின்னா, இந்த ஆக்ட் 2017 ஆக்டில் அட்மிரல்டி ஜூரிஸ்டிக்ஷன் ஹைகோர்ட்ஸுக்கு கொடுக்கும் பொழுது 2 விதமான ஜூரிஸ்டிக்ஷன், ஒன்று டெரிட்டோரியல் ஜூரிஸ்டிக்ஷன், இன்னொன்று சப்ஜெக்ட் மேட்டர் ஜூரிஸ்டிக்ஷன். சப்ஜெக்ட் மேட்டர் ஜூரிஸ்டிக்ஷன் மேரிடைம் கிளைம்ஸ் இல்லை மெட்ராஸ் ஹைகோர்ட்ஸ் அட்மிரல்டி ஜூரிஸ்டிக்ஷன் எக்ஸசைஸ் பண்ணலாம் அப்படின்னு சொல்லியிருக்காங்க. அது குறித்து மாண்புமிகு நீதியரசர் இருக்காங்க, அவங்க முன்னிலையில் நான் பேச வேண்டியதில்லை, அவங்க பேசுவாங்க. பட் வித் ரெஸ்பெக்ட் டு தி டெரிட்டோரியல் ஜூரிஸ்டிக்ஷன் ஆஃப் தி மெட்ராஸ் ஹைகோர்ட், இப்போ நம்ம நினச்சிட்டு இருக்கோம் மெட்ராஸ் ஹைகோர்ட்டில் இப்போ இது வரைக்கும் நீங்கள் என்னென்னா இந்த எந்தெந்த மாவட்டங்களில் ஜூரிஸ்டிக்ஷன் எக்ஸசைஸ் பண்ண முடியும் அப்படிங்கிறத பற்றி மட்டும்தான் உங்களுக்கு நீங்கள் யோசித்து பார்த்துருந்துருப்பீங்க. ஸோ திஸ் இஸ் சம்திங் நியூ தட் a new knowledge for all of you that the Madras High Court has a jurisdiction up to 22.24 kilometers in the ocean. In the side Bay of Bengal, அவ்வளோ தூரம் வரைக்கும் இந்த மதுரை ஹைகோர்ட் ஹேஸ் எ டெரிட்டோரியல் ஜூரிஸ்டிக்ஷன். அப்போது ஏதாவது ஒரு மேரிடைம் கிளைம் வருதுன்னா ஃபஸ்ட்டு நம்ம டிசைட் பண்ண வேண்டியது அந்த மேரிடைம் கிளைம் வந்து இந்த 12 நாட்டிக்கல் மைல்ஸ் இல்லைன்னா அந்த 22.224 கிலோமீட்டர்ஸ்க்குள்ளே இருக்கா அப்படிங்கிறதே நீங்கள் பார்க்கணும். ரைட், ஜஸ்ட் ஐ எம் டெல்லிங் ஹவு திஸ் ஜூரிஸ்டிக்ஷன் ஆஃப் திஸ் பர்டிகுலர் சப்ஜெக்ட். as I said, அந்த மாதிரி மேரிடைம் ஜோன்ஸ் எல்லாம் பார்க்கும்பொழுது நமக்கு வந்து இந்த டெரிட்டோரியல் வாட்டர்ஸ், அதுக்கப்புறம் 12 நாட்டிக்கல் மைல் வந்து யாருக்காவது தெரியுமா? யாராவது சொல்ல முடியுமா? டெரிட்டோரியல் வாட்டர்ஸ்க்கு அடுத்து 12 நாட்டிக்கல் மைல் மேலேயும் நமக்கு ரைட்ஸ் இருக்கு. இட்ஸ் கால்ட் அஸ் தி கான்டிகுவஸ் ஜோன். டெரிட்டோரியல் வாட்டர்ஸ் 12, அடுத்த 12 கான்டிகுவஸ் ஜோன், அதுக்கப்புறம் வந்து 200 நாட்டிக்கல் மைல்ஸ் வரைக்கும் இட் இஸ் கால்ட் எக்ஸ்க்ளூசிவ் எக்கனாமிக் ஜோன், over which India has exclusive economic rights. அந்த 200 நாட்டிக்கல் மைல் வரைக்கும் மீன் பிடிக்கணுன்னா நம்மளால் மட்டும்தான் மீன் பிடிக்க முடியும். அங்கே ஏதாவது ஆயில் எக்ஸ்ப்ளோர் பண்ணணுன்னா நம்ம மட்டும்தான் பண்ண முடியும். எனி எக்கனாமிக் எக்ஸ்ப்ளாய்டேஷன் ஒன்லி we can do. வேறு எந்த நாட்டுக்காரங்களும் பண்ணுறதில்லை. இந்த இந்தியா இலங்கைக்குள்ளே பிரச்சனை வர்றது வந்து இந்த மீனவர்கள் வந்து இந்திய பகுதியில் வந்து மீன் பிடிச்சிட்டாங்க, இல்லை இலங்கை பகுதியில் போய் மீன் பிடிச்சிட்டாங்க அப்படிங்கிறதுக்கு காரணம் வந்து இந்த 200 நாட்டிக்கல் மைல்ஸ் வந்து எங்கள் கடலில் வந்து காம்பவுண்ட் போட முடியாது இல்லைங்களா, வேலி கிடையாது. ஸோ யூ வில் நாட் நோ வேர் எக்ஸாக்ட்லி இட் எண்ட்ஸ். ஸோ தேர்ஃபார் ஃபிஷர்மென் வந்து மீன் பிடிக்க போகும்போது அவங்க இரவில் போகும்போது தே கிராஸ் தோஸ் லிமிட்ஸ் அண்ட் தென் அந்த கோஸ்ட் கார்ட் அவங்கள அரெஸ்ட் பண்ணிடுவாங்க. ஸோ இட்ஸ் குவைட் நேச்சுரல். அதே மாதிரி கடலுக்கு கீழே இருக்கிற அந்த நிலப்பரப்பு இருக்கு இல்லைங்களா, கடலுக்கு கீழே நிலம் இருக்கும் இல்லையா, தட் இஸ் கால்டு கான்டினென்டல் ஷெல்ஃப். அது வந்து ஒரு 200 நாட்டிக்கல் மைலுக்கு பேஸ்லைன்ல இருந்து 200 நாட்டிக்கல் மைலுக்கு நமக்கு வந்து we have rights over the continental shelf. ஸோ கான்டினென்டல் ஷெல்ஃபில் நமக்கு ரைட்ஸ் இருக்குது. அங்கே எக்ஸ்ப்ளோர் பண்ணலாம், மினரல்ஸ், மைனிங், அதுக்கெல்லாம் வந்து ஒரு இன்டர்நேஷ்னல் சீபெட் அத்தாரிட்டின்னு ஒன்று இருக்குது. அந்த சீபெட் அத்தாரிட்டியில் லைசன்ஸ் வாங்கி யூ கேன் டூ ஆல் தோஸ் எக்ஸ்ப்ளரேஷன்ஸ் ஆஃப் சீபெட் மைனிங், எஸ்பெஷலி இன் தி ஹை சீஸ் பியாண்ட் 200 நாட்டிக்கல் மைல்ஸ். ஸோ 200 நாட்டிக்கல் மைலுக்கு இருக்கிறதுக்கு அப்புறம் வெளியில் இருக்கிற கடலுக்கு பேர் ஹை சீஸ்னு பேர். அங்கே வந்து எவ்ரிபடி ஹேஸ் ரைட் இன்க்ளூடிங் இண்டியன்ஸ். till 200 nautical miles we have some special rights, beyond 200 nautical miles. இது மாதிரி ஒரு எக்ஸாம்பிளுக்கு சொல்கிறேன் ஒரு 5 நிமிஷத்தில். இது வந்து ஆக்சுவலாக நாங்கள் ஒரு செமஸ்டர் டீச் பண்ணுற சப்ஜெக்ட் இது. பிகாஸ் ஈச் ஆஃப் தீஸ் ஜோன்ஸ் ஹேஸ் வெரி வெரி ஸ்பெசிஃபிக் கைண்ட் ஆஃப் ரைட்ஸ் விச் வி நீட் டு டிஸ்கஸ் இட் அட் லெங்த். அதை எப்படி டீலிமிட்டேஷன் பண்ணுறதுலேருந்து அதை எப்படி மெஷர் பண்ணுறதுலேருந்து யூ ஹேவ் லாட் ஆஃப் திங்ஸ். அதுவும் குறிப்பாக ஆப்போசிட் கோஸ்டல் ஸ்டேட்ஸ் லைக் இந்தியா ஸ்ரீலங்காவுக்கு நடுவில் பார்த்திங்கன்னா லெங்க்த்தை ரொம்ப கம்மியாக தான் இருக்கும். அங்கே எங்கே 200 நம்ம 200 கிளைம் பண்ணி அவங்க 200 கிளைம் பண்ணுற அளவுக்கு அவ்வளோ இடம் இல்லை. இமேஜின் என்ன. ஸோ தெர் ஆர் சர்டன் வேஸ் ஹவு டு டீலிமிட் இன் த கேஸ் ஆஃப் ஆப்போசிட் கோஸ்டல் ஸ்டேட்ஸ், இன் த கேஸ் ஆஃப் அட்ஜசன்ட் கோஸ்டல் ஸ்டேட்ஸ். இதெல்லாம் வந்து பப்ளிக் மேரிடைம் லா. ஸோ வாட் ஐ வாண்டட் டு கன்வே இஸ், இப்போ என்னோட இந்த உரையில் வந்து நான் ஒரு 3 பகுதியாக பிரிச்சிருக்கேன். ஒன்று வந்து அபவுட் திஸ் பர்டிகுலர் செக்டர், இந்த மேரிடைம் செக்டரை பற்றி சில முக்கியமான தகவல்கள், just to prove the point that how ignorant we are towards this particular sector. இப்போ இந்தியாவோட நிலப்பரப்பு இருக்கு இல்லைங்களா, இந்தியா முழு தேசத்தோட நிலப்பரப்பு நீங்கள் வந்து மேப்பில் மெஷர் பண்ணிங்கன்னா எவ்வளோ ஸ்கொயர் கிலோமீட்டர்ஸ் இருக்குமோ அதே அளவு, அதற்கு நிகரான அளவு நமக்கு வந்து we have control over the territory under the waters. அப்போ எவ்வளோ வளமான ஒரு இதை வந்து நம்ம வந்து அதை பற்றி கம்ப்ளீட்டாக இக்னோர் பண்ணிட்டோம். நமக்கு முன்னாடி இருந்தவங்கெல்லாம் அதை பற்றி யாரும் அதை பெருசாக எடுத்துக்கல. we have such plenty of resources but then we never looked at it. அப்புறம் if you look at the global maritime trade எடுத்திங்கன்னா இன்றைக்கி ஆல்மோஸ்ட் நம்ம யூஸ் பண்ணுற ஒவ்வொரு பொருளும், இங்கே பார்க்குற இந்த ஏர் கண்டிஷனராக இருக்கட்டும், இந்த மைக்காக இருக்கட்டும், எதுவாக இருக்கட்டும், 80% of the international trade, global trade பற்றி பேசுகிறேன், 80% of the global trade happens through the sea route. 80%. மீதி 20% வந்து it comes through road, by railways, by air, all those things. 80% of the international trade happens through the sea route. இந்தியாவை பொறுத்த வரைக்கும் அது வந்து குளோபல் லெவலில், இந்தியாவை பொறுத்த வரைக்கும் 92% of the international trade in India is happening through the sea route. So just to sensitize all of you lawyers that how important this sector is in terms of the commercial transactions that are happening in this particular domain. இப்போ அந்த குளோபல் மார்க்கெட், மேரிடைம் மார்க்கெட்டோட வேல்யூ மட்டும் பார்த்தீங்கன்னா இட் இஸ் சம் 147 billion போன வருஷம் ஸ்டாட்டிஸ்டிக்ஸ், which is expected to reach almost close to 240 billions in 2030. I'm talking about in dollars. அந்த மாதிரி if you look at the India's maritime sector, let's not talk about global sector, ஏதாவது நடந்துட்டு போட்டோம், இந்தியாவை பொறுத்த வரைக்கும் இப்போ நம்ம வந்து we have not been using these resources for long, the maritime resources. எதுக்காக மேக்ஸிமம் நம்ம மேரிடைம் ரிசோர்ஸை யூஸ் பண்ணியிருக்கோம்னா, மீனவர்கள் மீன் பிடிச்சி கொண்டு வருவாங்க, காலையில் நம்ம மார்க்கெட்டில் போய் வாங்கிட்டு வந்து மீன் குழம்பு வச்சு சாப்பிட்டுருக்கோம். To that extent only we have used this maritime sector, not too much beyond that, right? But then ocean can provide a lot more. அதனால தான் வந்து இப்போ வந்து we have such very important schemes like the Maritime India Vision 2030, the Amritkal Vision 2047. இதிலெல்லாம் வந்து now the government is focusing its fullest attention towards developing the maritime sector. So this is the importance of this period, and young lawyers here, it's an immense opportunity for all of you to become an expert in this area because we do not have experts. சார் சொன்னாங்க இல்லைங்களா, 30 வருஷத்துக்கு முன்னாடியே சார் வந்து அதை ஆன்டிசிபேட் பண்ணி, இந்தியாவில் வேறு எந்த யூனிவர்சிட்டிலையும் மேரிடைம் லா கோர்ஸ் கிடையாது சார், லண்டனில் போய் மேரிடைம் லா படிச்சுட்டு டுடே he is considered as an authority in the entire nation on maritime law. We are extremely grateful that sir retire ஆனதுக்கப்புறம் he had been a great source of support to our university. As Vice Chancellor of that university, I requested sir to be a professor of practice to teach our students, because we are the first and maybe the only university which offers a master's degree program in maritime law. We have an LLM in maritime law. It's a 1-year program. It's a residential program, so we teach maritime law, and we need this kind of expertise. So we have requested sir to be a professor of practice of Gujarat Maritime University, which I am publicly announcing today, sir, which you have been kind enough to accept that request to be a professor of practice. Now, inimelte sir and the justice shed pannittu, now he can be called as Professor K.R. Sriram. He has been very kind enough, and after accepting to be a professor of practice, this is the first program he is attending in Madurai on behalf of our university. So we are greatly honored to have such eminent people with us teaching our students maritime law, and it's amazing. As I said, first on the speech, because I'm not going to get into the Admiralty law per se, but then I will be largely giving you an overview of it. But I will leave it to Honorable Justice Sriram to speak about the depths of this particular subject. Some important statistics I would want to give you to prove the point that how this sector is emerging. Port capacity in India's total port capacity is now, it's almost doubled in the last 10 years, from 1,400 to 2,800 million metric tons per annum. You can see the volume of business that's happening. Cargo volumes. Major ports handled roughly 855 million tons of cargo only in last 1 year. The third important thing is the operational efficiency of the ports have improved because of modernization, because of use of technology. முன்னாடி எல்லாம் அந்த அன்லோடிங் எல்லாம் மேனுவலாக பண்ணுவாங்க, இப்போல்லாம் வந்து எல்லா போர்ட்லேயும் ஆக்சுவலாக இப்போ கன்வேயர் பெல்ட்ஸ் எல்லாம் வந்துருச்சு. நேராக கொண்டு போய் கன்வேயர் பெல்ட்டை ஃபிக்ஸ் பண்ணிவிடுவாங்க, கப்பலில் இருந்து தானே சரக்கு இறங்க ஆரம்பிச்சிடும். முன்னாடியெல்லாம் ஆளுங்க போய் தூக்கி கொண்டு வந்து இறக்கணும். அதனால் என்னாச்சுன்னா ஒரு டேர்ன் அரவுண்ட் டைம் அட் மேஜர் போர்ட் வாஸ் ஆல்மோஸ்ட் க்ளோஸ் டு 4 days. ஒரு கப்பல் வந்து ஒரு போர்ட்டில் நின்று எல்லாம் டீபோர்டிங் பண்ணி அன்லோட் பண்ணிட்ட பிறகு திரும்பி அது சரக்கை ஏற்றிட்டு போகிறதுக்கு 4 நாள் ஆகும். பட் இன்றைக்கி வந்து பிகாஸ் ஆஃப் தி specific schemes by the government, because of the port modernization, the operational efficiency as ports has now come to 48 hours. ஸோ 2 நாளில் இப்போ கப்பல் வந்துட்டு அடுத்த நாளே போகக்கூடிய அளவுக்கு இது வந்துருக்கு. This is a very, very important fact that all of you need to know if you intend to practice in Admiralty law, because now the ships can come and go very quickly. You will have to, if at all you have a client who wants to file a maritime claim using the Admiralty jurisdiction of the High Court, you will have to do it within 1-2 days before the ship leaves the port. So therefore this factor is a very, very important factor for all of you to know. அதே மாதிரி இந்த கடலில் அந்த கப்பலில் வேலை செய்கிறாங்க இல்லைங்களா சிப்பந்திகள், இந்த சீஃபேரர்ஸ் அப்படின்னு சொல்லக்கூடியவங்க, இந்தியா சப்ளைஸ் ஆல்மோஸ்ட் 12% ஆஃப் தி குளோபல் சீஃபேரர்ஸ். அண்ட் தே ஆர் கவர்ன்ட் பை அ டிஃப்ரெண்ட் செட் ஆஃப் லேபர் லாஸ். நம்ம லேபர் லா அவங்களுக்கு அப்ளை ஆக, தே ஆர் கவர்ன்ட் பை தி மேரிடைம் லேபர் கன்வென்ஷன் த்ரூ விச் தே ஆர் கவர்ன்ட். ஸோ உலகத்தில் இருக்கக்கூடிய சீஃபேரர்ஸில் 1 in 10 seafarer will be an Indian. அதுலேயுமே கூட நிறைய வாய்ப்பு இருக்குன்னு, இன்னும் நம்ம நிறைய கான்ட்ரிபியூட் பண்ண முடியும். We can take a major share in it because not many countries, people, nationals of those countries join as a seafarer. Highest seafarers nation is Philippines, right? ஸோ அது மாதிரி இப்போ கவர்மெண்ட் வந்து நிறைய இப்போ இந்த சாகர்மாலா ஸ்கீம்னு ஒன்று கேள்விப்பட்டிருப்பீங்க. இந்தியா முழுக்க அந்த என்டையர் கோஸ்ட் லைன் ஃபுல்லாக அந்த போர்ட்டை இது டெவலப் பண்ணி கனெக்டிங் தி என்டையர் நேஷன் த்ரூ த சீ ரூட். இப்போ நம்ம வந்து பாம்பேலேருந்து தூத்துக்குடி வரணுன்னா ஐ வில் ஹாவ் டு உடனே என்ன பார்ப்போம், ஃப்ளைட் இருக்கான்னு பார்ப்போம், இல்லை ட்ரெயின் இருக்கான்னு பார்ப்போம், யாராவது கப்பல் இருக்கான்னு பார்ப்போமா? பட் வரலாம் இல்லையா? நம்ம அந்த லைனில் யோசிக்கிறது இல்லை. ஏன்னா நம்ம வந்து அந்த பக்கம் அப்படி ஒரு வழி இருக்குது, அப்படி ஒரு வர்றதுக்கான வசதிகள் இருக்குது அப்படின்னு நம்மளும் நினைச்சதில்லை, அரசும் நினைச்சதில்லை, யாருமே நினைச்சதில்லை. ஸோ வி ஹவ் பின் லிட்டரலி பிளைண்ட் டுவர்ட்ஸ் தி சீ ரூட்ஸ். இதே மாதிரி நம்ம ரயில்வே ஸ்டேஷன் எப்படி இருக்கோ, நம்ம பஸ் ஸ்டாப் எப்படி இருக்கோ, அதே மாதிரி ஒவ்வொரு போர்ட்லேயும் வந்து தெர் ஆர் ரெகுலர் டைம் வென் த ஷிப் கம்ஸ், பிக்ஸ் அப் பேசஞ்சர்ஸ், பிக்ஸ் அப் கூட்ஸ், and then they move on to the next port. கரெக்டாக அது லைனர் ட்ரேடுன்னு சொல்லுவாங்க. அதில் இந்த ஒவ்வொரு போர்ட்லேயும் பார்த்தீங்கன்னா அந்த டைம் டேபிள் இருக்கும், எந்த டைமுக்கு எந்த கப்பல் வரும், அந்த கப்பல் இங்கே இருந்து பொருளை எடுத்துகிட்டு எந்த இடத்துக்கு போகும், அங்கே எத்தனை நாளைக்கு என்னைக்கு போய் சேரும், எத்தனை மணிக்கு போய் சேரும், அந்த டைமிங் எல்லாமே நம்ம ட்ரெயின் ரயில் அட்டவணை ஃப்ளைட்ஸ் மாதிரி சீ ரூட்லேயும் இருக்குது. பட் நமக்கு அதை பற்றியெல்லாம் ஒன்றும் தெரியாது. Now let's come to the maritime sector in Tamil Nadu, because we are very much keen in knowing how this sector is developing. But Tamil Nadu எடுத்துட்டோம்னா there are 3 major ports. ஒன்று வந்து சென்னை போர்ட், the original port. ரெண்டாவது வந்து எண்ணூரில் கிரியேட் பண்ணியிருக்கக்கூடிய காமராஜர் போர்ட், that is the second major port. Third major port is V.O. Chidambaram port, தூத்துக்குடி, which comes within your jurisdiction, Madurai High Court jurisdiction. அதில் பார்த்தீங்கன்னா out of these 3 ports, you see the most important major activities happen at the V.O. Chidambaram port. அங்கே அந்த போர்ட்டோட ஆக்டிவிட்டீஸ் எல்லாம் பார்த்துங்க, they have reached their annual target of 41 million tons, 11 days ahead of the schedule in March 2026. See the amount of volume. Container traffic grew by 8% year on year. So they are handling almost 6 lakh 20 foot equivalent units of containers. 20 feet equivalent of unit of T, அது ஒரு மெஷர்மெண்ட் மெட்ரிக்கு. ஸோ இட் இஸ் ஆல்மோஸ்ட் லைக் ஒரு பெரிய கண்டெய்னர் லாரின்னு சொல்லுவோம் இல்லைங்களா, லாங்காக இருக்கும் இல்லையா. ஸோ அது வந்து ஒரு கண்டெய்னர் தானே எடுத்துகிட்டு போக முடியும் ஒரு லாரி. பட் a ship can take thousands of such containers ஒரு ஷிப்பில். ஸோ தூத்துக்குடியில் மட்டும் போன வருஷம் மட்டும் 6 லட்சம் கண்டெய்னர், அந்த மாதிரி அந்த சைஸ் கண்டெய்னர்ஸ். அண்ட் சிமிலர்லி you see the strategic growth of the all these, especially I'm just confining myself to the Thoothukudi port. Now, if you look at Tamil Nadu, they are trying to emerge as a shipbuilding hub because நம்ம கிட்ட இருக்கிற கடல் வசதி, நம்ம கிட்ட இருக்கிற போர்ட் வசதி வச்சுட்டு கடல் இந்த ஷிப்பில்டிங் யார்ட்ஸ் இப்போ இருக்கு ஒன்று காட்டுப்பள்ளியில் சென்னையில் எல்என்டி வந்து ஒரு ஷிப் பில்டிங் யார்ட் பண்ணியிருக்காங்க. பட் தே குட் நாட் கம்பீட் globally because of the cost involved in constructing a ship in India. It's almost 3 times more than what you can buy the same ship in China because of various reasons. So we need to find out all those things. But still, the state government, the Tamil Nadu government is implementing the maritime transport manufacturing policy. அப்படின்னு போட்டுட்டு அதில் ஒரு 30,000 கோடி இன்வெஸ்ட் பண்ணி they are working on this particular project, which the government hopes that it will generate 55,000 jobs. அதே மாதிரி பார்த்தீங்கன்னா தி சென்னை போர்ட், காமராஜர் போர்ட், எண்ணூர் போர்ட் ப்ளஸ் கடலூர் கிளஸ்டர் that is being developed to reach a combined capacity of 300 million metric tons per annum. இப்போ தமிழ்நாட்டில் மட்டும் பார்த்தீங்கன்னா 98 சாகர்மாலா ப்ராஜெக்ட்ஸ் worth 93,376 crores-கான ஒர்க் நடந்துட்டு இருக்கு. And the key developments include a 1,424 crore multimodal logistic park at a place called மாப்பேடு மெட்ராஸில் தாம்பரம் பக்கத்தில் சிறுசேரி பக்கத்தில் இருக்கக்கூடிய ஒரு இடம், அங்கே டெவலப்மெண்ட்ஸ். திஸ் செக்டர் இஸ் க்ரோயிங் லைக் எனிதிங், ரைட்? இன்னைக்கு நம்ம மெயினாக யூஸ் பண்ணக்கூடிய ஈவிஸில் யூஸ் பண்ணக்கூடிய பேட்டரிஸ், அந்த பேட்டரிஸ்க்கு முக்கியமான அந்த ரா மெட்டீரியல், இட் இஸ் தோஸ் nodules are available only under the sea. So mining of those things are very, very essential, but then we have not been able to successfully do it for various reasons. That is anyway, that's outside the scope of this seminar, this workshop. அதனால் அதை இன்னொரு நாளைக்கு வேற எப்பயாவது பேச முடியும். ஏன்னா இந்த ப்ரோக்ராமுக்கு நம்ம ஏன் வந்தோம் அப்படின்னதே வந்து குஜராத்தில் இருந்து ஏன் மதுரைக்கு வந்தாங்க அப்படிங்கிற அந்த கேள்வி யாருமே கேட்கல என்கிட்ட. ஏன்னா குறிப்பாக வந்து I have few of our lawyers keep coming to Gujarat. I can see அழகுமணி சார் தான் லேட்டஸ்ட்டாக வந்தார், ஒரு லாஸ்ட் மந்த் வந்திருந்தார். அதுக்கு முன்னாடி கருணாநிதி had come, அதுக்கு முன்னாடி செல்லப்பாண்டியன் has come. So many of them they keep coming for our programs in our university. So இந்த முறை ரீசெண்டாக இப்போ when அழகுமணி came, then he was discussing about the Elsa case, MSc Elsa. அந்த கேஸை பற்றி கேள்விப்பட்டிருக்கீங்களா? எத்தனை பேருக்கு தெரியும் MSc Elsa கேஸ் பற்றி? ஒரு அது வந்து திருவனந்தபுரத்தில் கேரளா கோஸ்டில் ஒரு கரெக்டாக எக்ஸாக்டாக அவுட் சைட் த டெரிட்டோரியல் வாட்டர்ஸ் அந்த கப்பல் மூழ்கிடும். அதை மூழ்கினது கப்பலோடைய அந்த அதனால் ஏற்பட்டக்கூடிய சுற்றுச்சூழல் சம்பந்தமான இதெல்லாம் வந்து நிறைய இட் ஹஸ் காஸ்ட் லாட் ஆஃப் டேமேஜஸ் டு எஸ்பெஷலி பீப்புள் இன் Kerala. So therefore the people in Kerala, they approached the Kerala High Court under the Admiralty jurisdiction. அதில் வந்து பார்த்தீங்கன்னா what they have done is the Kerala High Court ordered 9,531 crores as compensation. ஒரு கோடி 2 கோடி இல்லை, 9,531 crores they ordered to be paid as a security deposit. And since the shipping company refused to pay that amount, then the Kerala High Court ordered the arrest of the MSc sister ships. அந்த கம்பெனிக்கு சொந்தமான வேற கப்பல்கள், ஒரு கப்பல் தான் மூழ்கிடுச்சு, அந்த எல்சா மூழ்கிடுச்சு. But they had to take action against the company. That company is it's registered in Liberia. Liberia, sir. Geneva, okay. Yeah, okay, sir. So இந்த கப்பல் அவங்க கிட்ட இருந்து அந்த ரெக்கவர் பண்ணுறது வந்து ரொம்ப கஷ்டம் அப்படிங்கிறதுனால they have ordered the arrest of 1, 2, 3, 4 ships, 4 sister ships of MSc. Vilinjam portla irukum பொழுது they have ordered the arrest of that. So this is something, because this what we need to understand is a ship is a moving commercial asset. It's a moving asset, illaya, just like it's bigger than a 5-star hotel, but it's moving, it keeps moving from one place. And the problem is the legal challenges in complexities. It may be owned by national of one country, managed by a company, like as I said, இப்போ நான் சொன்ன லைப்ரரியாவில் இருங்க, பட் சார் உடனே திருத்தினாங்க, லைப்ரரியாவில் ரெஜிஸ்டர் பண்ணியிருக்க அந்த கம்பெனி, அந்த ஷிப்பு, பட் த கம்பெனி who are the owners of that, they have their office in Geneva, in Switzerland, right? So it's managed in another country, insured in some other country. Maybe one of the P&I clubs in London must have insured that. Crewed by nationals of several countries. அது உள்ள இருந்த crew members வந்து they must be ஒரு 4 பேர் பிலிப்பினோ இருப்பான், 4 இந்தியன்ஸ் இருப்பாங்க, ஒரு 4-5 பேர் நைஜீரியன்ஸ் இருப்பாங்க, ஒரு 4-5 பேர் போலிஷ் நேஷனல்ஸ் இருப்பாங்க. ஸோ அந்த மாதிரி you have lot of variety of people in that. So how do you exercise jurisdiction? What law applies to them? And they must be carrying the cargoes linked to multiple jurisdictions. அதில் இருக்கக்கூடிய அந்த கப்பலில் இருக்கக்கூடிய கார்கோ வந்து ஒரு ஆளுக்கு சொந்தமானதாக இருக்காது. அதில் இருக்க ஒரு போர்ஷன் வந்து இந்தியாவில் யாராவது வாங்கியிருப்பாங்க, அவங்களுக்கு கொண்டு வந்து இங்கே கொடுக்கணும், இங்கே கொடுத்துட்டு சிங்கப்பூரில் கொடுக்கணும், சிங்கப்பூரில் கொடுத்துட்டு வியட்நாமில் கொடுக்கணும். அப்போ அந்த கப்பல் போகிற வழியெல்லாம் வந்து that cargo does not belong to one particular entity, it belongs. So you can't arrest a ship and keep it with you with the cargo belonging to somebody else. You understand the complexities involved in this case. So that is why this law has become a very, very important law, and that is why I just wanted to take this opportunity to explain why the law treats ships differently from ordinary property. Because a ship is not merely a movable machine, it is a high valuable commercial asset, it is a workplace, it is a carrier of goods, and often the only effective security available to a claimant in a maritime dispute. நான் சொன்ன மாதிரி, let's imagine a context where the ship owner may be located in some other country, the operating company may be existing or may be a shell entity, and the vessel itself may sail away before any effective relief can be obtained. இது இந்த மாதிரியான ஒரு சர்க்கம்ஸ்டான்ஸில் you need to have a very, very effective legal remedy to address, to protect the interests of your clients. Admiralty law responds to this practical reality by allowing the vessel itself to become the focal point of the claim. Instead of the owner, which in a normal thing, if somebody is not repaying the money, you take action against the person. But here you take action against the ship, the vessel, which itself becomes the focal point of the claim, treating it in a legal sense as the defendant through actions in rem. This is something very, very important thing. I believe sir will be explaining what are these actions in rem and actions in person. This distinctive feature of Admiralty jurisdiction is not a recent innovation. இது வந்து நம்ம இப்போ பேசிக்கிட்டு இருக்கோம், but it's not a recent innovation, but it has deep historical roots. Like நம்ம ஜட்ஜ் சொன்னார் இல்லைங்களா, சதீஷ்குமார் சார், Admiralty Act 1840, 1861. ஸோ அந்த மாதிரி இவால்வ் ஆகிக்கிட்டே வரக்கூடிய சப்ஜெக்ட். அன்டில் 21st April 2018, when this law came into force, the 2017 Act, இங்கே போட்டிருக்கோம் இல்லையா, அந்த Maritime Claims Act 2017 Act, this act came into force on 1st April 2018. Until that, we were governed by the Admiralty law of 1861, right? And the law was evolved through judicial precedents, and that is the major change. What has happened is this judicial evolution built over time through precedent and practice was consolidated and modernized by the Admiralty Jurisdiction and Settlement of Maritime Claims Act 2017. So இதில் வந்து மெயினாக நீங்கள் தெரிஞ்சிக்க வேண்டியது ரெண்டு. ஒன்று வந்து jurisdiction, ரெண்டாவது what do you mean by a maritime claim? I don't think anyone else other than Justice Sriram can explain it so beautifully with real examples, because sir has handled so many cases involving maritime claim, maritime lien, and all those things. So I will leave it to him to explain that. This main interesting thing, what many law, you must have heard anything about Admiralty law. You must have the one very interesting word that all of you, which would have attracted the attention of all of you, is the arrest of a vessel, arrest of a ship. Innum kuda nariya judges they ask this question, how to arrest a ship? Because we, to lawyers who are not familiar with the maritime practice, the word arrest may sound as a punishment. But in Admiralty law, it is usually understood as a method of securing the claim. See, on the High Court law, arrest order vaangilla, but on the order execute panni, and the ship and the port out to pogama nirthi vaikira and the process irukku pathingala. I've seen my students, getting an arrest order in Chennai, and by the time the arrest order, the copy is received, the ship must have sailed to Visakhapatnam. So, ingerundu odane Visakhapatnam poi and the order execute pandradhukku try பண்ணுவாங்க. If we very recently also we had a case where Patanjali, they imported oil, palm oil from Malaysia, which was taken out of this vessel. So what do you call that word, sir? Unloading. Unloaded the palm oil which they imported from here. But then they found that after getting unloading, they found that it was almost 20 metric tons of oil was less in quantity. So அங்கே ஏற்றும்போது கரெக்டாக ஏற்றிருக்காங்க, இங்கே இறக்கும்பொழுது 20 மெட்ரிக் டன்னுக்கு அளவுக்கு ஆயில் குறைஞ்சிருக்கு. It's a huge amount. No, who will suffer the loss? But by the time when they noticed that the loss is there, the ship had sailed. But fortunately for Patanjali company, so this ship was sailing towards another port in Gujarat. So when the ship reached a port in Gujarat, then they got an arrest order in Gujarat and tried to execute this maritime claim against that ship in Gujarat. So this is the importance of this subject. It's a very, very interesting subject, and it has so many things like now there are many students when they come, they ask about questions, sir, why do you expect that all these cases will come to Admiralty courts? Why can't they resolve it in an arbitration proceedings? So this is again something very, very interesting thing which I believe sir will be telling, because there is a lot of things what you can't do through arbitration, or what will not be as effective as exercising your Admiralty jurisdiction, what can be done through an arbitration. So those things are there. Similarly for Admiralty and insolvency, now the new IBC had come. I was told that even IBC is something we need to do to increase awareness of this. எத்தனை பேருக்கு IBC பற்றி தெரியும் உங்களுக்கு, Insolvency and Bankruptcy Code? It has now created a new generation of legal practitioners called Insolvency Resolution Professionals, IRPs. New kind of, you should all prepare, especially young people, you should not get stuck to this High Court and start doing the same thing your brothers and your fathers were doing. You will have to look for newer opportunities. So you should be sharp enough to see what are the legal developments that's happening in this country. IBC vandadukku piragu, you have a separate system of courts which had come, the National Company Law Tribunal, which has been given this jurisdiction to deal with IBC cases. NCLT இருக்கு, அதுக்கப்புறம் இங்கிருந்து அப்பீல் வந்து it goes to NCLAT, right? So that is again a very, very different and unique kind of a field which you will love handling those cases. So that is something which you need to do all these things. So therefore, that is what is the idea behind this particular workshop. So I wish to just conclude by telling all the lawyers who are new to this field that do not think of Admiralty law as something which is remote or exotic. Think of it as a specialized but deeply practical response to a world in which assets move, parties come from different countries, and justice must sometimes be secured before it can be finally adjudicated. That is why Admiralty jurisdiction continues to matter, and that is why conversations like this matter as well. And that is why as a university we had come this far to create some kind of an interest in the lawyers, because I will tell you why this university was created. Why this university was created in 2019. Gujarat Maritime University was created by our Honorable Prime Minister in 2019. And I was the first officer to be appointed. I am the Vice Chancellor of that university. In 2019, I was given the charge by the Prime Minister to take care of this university. And his vision was this, that he said that we are now doing lot of things to develop maritime sector. Lot of things are happening: port privatization, port infrastructure development, modernization of ports, multimodal logistics. We are trying to strengthen the complete maritime sector. But we need people, isn't it? We need trained people to handle these developments which is happening around the country. எத்தனை ஆயிரம் கோடிகள் நான் சொன்னேன் ஏற்கனவே. அவ்வளோ பணம் இன்வெஸ்ட் பண்ணி இவ்வளோ இன்ஃப்ராஸ்ட்ரக்சர் கிரியேட் பண்ணி இவ்வளோ இதெல்லாம் பண்ண பிறகு, பட் வி நீட் பீப்புள். Seafarers we will get, there is abundant supply. But senior people, at a management level, we will not get competent people. And no university teaches them. Then since this act came in 2017, and now 9 high courts, out of 9, 3 were original high courts, Bombay, Calcutta, Madras. Remaining 6 high courts are given this jurisdiction freshly in 2018. And none of the judges, none of the lawyers in these high courts are trained in Admiralty law. So therefore the Prime Minister said that in case we are giving jurisdiction, but if there is a dispute comes, whether this court will be able to handle it. So we need to train manpower. And that is the reason why this university was established in 2019. In fact, it was established in 2018, but in 2019, after my joining, I initiated all the activities. We admitted the first batch in 2019, a set of students who are working, now all of them are working globally with multiple shipping companies, multiple law firms specializing in maritime law, and they are all doing very, very well in their professional life. Then after starting the maritime law program, then we started some MBA program where we wanted to have managers who are trained in handling ports. So we have an MBA in port administration. We have an MBA in shipping and logistics. That's a different sector. It's a different world altogether. Each and every word used in the maritime sector is completely new. It's not the normal English that you will be able to like, bunkering. What is bunkering? Right? Have you heard of this word called bunkering? யாருக்கும் நமக்கு தெரியாது. But it's nothing but it's fueling. கப்பல் வருதுன்னா அந்த கப்பலுக்கு தேவையான fuel பண்ணி அனுப்பணும் இல்லையா, ரீஃபியூல் பண்ணணும். That process is called bunkering. நிறைய நேரம் என்ன பண்ணுவாங்கன்னா அந்த பங்கரில் அந்த ஃபியூல் வாங்கிட்டு கிளம்பி போயிடும். Then the person who supplied the fuel he will be left without any legal remedy. So these are the possible circumstances. So we have MBA in port administration, we have an MBA in shipping and logistics. Now we have started a new program for the Institute of Company Secretaries, especially for those who are company secretaries. For them we run a special 2-year MBA program. It's called Maritime Regulations and Compliance Management. So as company secretary, they will have to ensure that the shipping companies comply with all these legislations, because shipping is a highly regulated sector. And you have a separate regulatory body called the DGCA. Sorry, not DGCA, the Director General of Shipping. DGCA is civil aviation. Director General of Shipping is based at Mumbai, and they do everything relating to ships, right from registering a ship to giving it the registration number, to training certifying the crew, to everything. Whatever you need to know about shipping is done by the DG Shipping. And it's very, very nice opportunity for us to come and showcase before all of you the developments that's happening in this particular sector. So I have a special love for this city, right, for Madurai. It's because that I came as a young man to Madurai to teach at the Government Law College, Chennai. That was the first time I am coming out of Chennai, so I never knew how Madurai will look like. So it was exactly in 2000, year 2000, September, I landed in Madurai. It was all new. But then I started loving this city, especially because of the people. And one more reason, personal reason why I love this city is my wife is from Madurai. So obviously I had to love this city, and hopefully I would also want to come and settle down in this city if God permits. Thank you so much to the Madurai Bar Association for giving me this opportunity. Thank you so much.
Thank you, sir. You have given a different perspective of the maritime laws. You have delivered a unique enlightenment speech on the maritime laws. Always Professor Santakumar given innovative ideas to the students. As we student grow with him, always spend time, me, Kasina, Duryanna and Robert Anna, many of us here, always with his chamber. We were most of the time at his personal chamber only at the law college. Because of his innovative ideas and his inspiration teaching and given more ideas to come up in the life. Similar, we as a Tamil Nadu, we lost him as a professor here. I would say that because several his most important teaching as a students, we have lost it. Now, Honorable Mr. Justice K.R. Sriram, our most recent former Chief Justice, as well as the Rajasthan High Court. His Lordship delivered several landmark judgments in diverse fields, including temple fund protection, taxation, revenue, labor rights, commercial law, maritime law. He was holding LLM in maritime law from King's College, London. His Lordship widely regarded as an authority in this field, and he delivered several landmark judgments, including in Rod Shipping Agency versus Bach Mathwa, is considered a seminal on the interplay between Admiralty law, company law, and the Insolvency Bankruptcy Court. Shortly after assuming office of Chief Justice, I remember His Lordship delivered a judgment with regard to maternity benefits. He held that the maternity benefit should not only restricted to the government employee, it should also expand to the contractor laborers. He held many judgments through his judgments, and apart from the maritime law and others, he did several administrative reforms also as a Chief Justice of our Madras High Court. I request Lordship Mr. Justice K.R. Sriram to deliver keynote address.
எல்லோருக்கும் மாலை வணக்கம். நான் நினைத்தேன் 3 to 6 டைம் சொல்லியிருந்தாங்க, அது 5 to 7 சொன்னாங்க. 6:20க்கு எனக்கு ஸ்டேஜ் கொடுத்தாங்க. 7 மணிக்குள்ளே எல்லாருக்கும் பசிக்கவும் தொடங்கும். So nobody will have food for thought. Their thought will be on food by the time it hits 7. I'm extremely grateful, I would say, the term used for the Madurai Bar Association, as also the Gujarat Maritime University, for inviting me here. ஏன்னா உங்கள்கிட்டெல்லாம் விடை பெற்று போக முடியலை எனக்கு. அப்படியே அங்கேருந்தே சென்னையிலிருந்தே ஓடி போயிட்டேன்னா. So at least I got a chance, and I should tell you, I enjoyed my visits to Madurai. And when I last came here in July, early July, I had contemplated to spend minimum 2 weeks, not 2 days that I used to do in the first week of August. But first week of August I was heading a bench in Jaipur. Circumstances are such. But Dr. Shantakumar mentioned about the Admiralty jurisdiction and the kind of maritime claims. If I have 5 hours, I can keep you enthralled with so many stories and so many matters. Having said that, why Madurai? நான் வக்கீல், எவ்வளவு கேஸ் வரும் எனக்கு மதுரையில் Admiralty. That thought will, it's but natural. It's not just being an academic and learning a subject. If even to me, if you come and tell me, read this subject, Land Reforms Act of Tamil Nadu, it's a major effort unless somebody says, hey, so many opportunities you will have. Now, அவர் சொன்னார் எவ்வளோ கேஸ் நடக்கிறதுன்னு. There are varied field you should get out of your complacency or comfort zone, I would say, to grow. Only after I became a judge, I knew there was great opportunity in getting caste certificates. Bombay, there are lawyers who have two Mercedes Benz, only getting caste certificate is their pure practice. I did not know. Because, of course, I was confining myself to this jurisdiction. I was doing well. So when you're doing well and there is a lot of money coming and you're busy all the time, would you want to put things aside? You will have no time also to think. But having said that, yesterday, Professor Dr. Abhay Singh, me and one of you, Sharat Chandran, he's also staying in the same hotel where I am staying. So when my wife and I, we were having dinner with Dr. Abhay Singh, he also happened to come. And a thought which came across our mind, you will have to do a little bit of reading. It's interesting, it is just hardly this thick. Okay, 15 sections. Not something which like Companies Act or Merchant Shipping Act, which has 240 sections, or Income Tax Act. High Court. See, now earlier when I was practicing, before this 17 Act came into force, Bombay High Court would arrest a ship in Chennai. Bombay High Court would exercise jurisdiction over a ship in Paradeep, in Odisha. I have gone to Navalaki, a small port in Gujarat, to execute a warrant of arrest with the sheriff for a foreign client because they did not have any representative here. My senior said, I poitu vaada konjam kaas pannittu vaana. These 3 chartered high courts could exercise jurisdiction all over the territorial waters of India. And Bombay ruled the roost. Then this act came, which has now given jurisdiction to 8 high courts. So like Dr. Shantakumar mentioned, do you have people to manage those courts and jurisdictions? I'll be candid, no. Barring 1 or 2 courts. Others are learning, judges are learning, but for judges also to learn, you need to have lawyers from Madras or Bombay to go and argue. So having said that, one of the high court which has jurisdiction is Madras. Would Madras include a bench? Or is it only the principal seat? That was the talk which we were having. So if a bench also can exercise jurisdiction, why not the bench arrest ships in Thoothukudi? The nautical miles that he mentioned is where the ship will be, not your road territory. If a ship is within 12 nautical miles, the High Court can exercise jurisdiction over that ship. One thing he said in the end, in his conclusions, arrest is to get security. Correct? Answer is yes. But that is not the sole purpose. That is secondary. Well, or rather, let us say that is the originating thing. By issuing the warrant of arrest and executing the warrant of arrest, by arresting the ship, the court assumes jurisdiction over the ship. Now you all lawyers know who is the defendant? Mr. X, Mrs. X, Messrs. X, Messrs. X Limited, correct? In an Admiralty suit, that is the beauty of that subject. Make a note. He said M.V. Elizabeth is old of Justice Kochuthoman and Justice Sahai. Harvan Shipping versus M.V. Elizabeth. It originated from Hyderabad. And the interesting part, which of course jurisdiction was, can you arrest a ship for an export cargo and not an import cargo? That was the origin. And then it expanded and then helped us get this beautiful jurisdiction. And then my own judgment, if you read, which was also mentioned, Raj Shipping Agencies versus Barge Madhwa. It is also reported in Lloyd's Law Reports of London, which he mentioned it was an interplay between these three different jurisdictions. That would give you, just use it as a bedtime reading. நல்லா எழுதுறேன்னா எழுதிட்டு இருந்தேன் நோவல் படிக்கிற மாதிரி நைட்டில் படுத்துட்டு படிச்சு பாருங்க. Why? How? Because that is how they exercise jurisdiction. Ship is a moving asset, etc., etc., he said. What does the ship do? Can receive cargo at port A, go discharge the cargo in port B. It could be from Bombay to Lisbon in Portugal. It could be Singapore, bring cargo from Singapore to Bombay or Chennai and Chennai to Thoothukudi. From Thoothukudi she will sail away. Correct? You noticed one word, I said she will sail away. A ship is always referred to as a she. That you look up why. There are jokes also to that. It's very expensive to, for her upkeep is very expensive. That's what they say. And she is moored to a buoy. That is B-U-O-Y. So when a ship sails away, like he mentioned also about bunkering. Bunkering is fueling. When you supply bunker, நீங்க பெட்ரோல் பம்ப்ல போய் பெட்ரோல் ஊத்துறீங்க உங்க வண்டியில. நான் அன்னைக்கு போன வாரம் பம்பாயில் கார்டு இல்லை, நான் ஸ்கேன் பண்ணணும்னா ஜிபேல நான் சரிப்பா கொடுக்கறேன்னு. சார் ஃபர்ஸ்ட் ஸ்கேன் பண்ணி 4000 ரூபா போடுங்க, பின்னதான் ஊத்துவேங்கிறான். But here such things don't work, and there are multiple suppliers. That competition is so high. So if she sails away, then what happens? Or you have somebody has supplied fuel, let's say in Paris, Marseille in France, or Italy, Genoa in Italy. Payment not made. The owner of the ship is based in Panama or British Virgin Island. She is flying a flag of Honduras. One ship owner, the ship never goes back to Genoa. How do you claim? So the ship, when she comes to Bombay or to Chennai, you all, it's academic. What I said about Madurai exercising jurisdiction over Tuticorin is something which is really a research which you all should, even to make it an academic article. Make it an academic article. How do they recover the money? That is by, I don't even know who's the owner. So I treat the ship as a person and then sue the ship. So if the supplier is Indian Petroleum Corporation or Italian Petroleum Corporation. The title will be Italian Petroleum Corporation versus MV. MV is motor vessel. MV, Neo. That's the name of the ship. That's all. Only one defendant, which is the ship. It is not, you don't need to make the owner. Of course, certain disputes may require the owner or charterer, etc. But if you say MV Neo flying the flag of Honduras along with her hull, tackle, appurtenances, etc., presently lying, now you have to say the port of Madras. Then you move the Madras High Court for the arrest. Earlier we could say it lying in the port of Kandla also. So that is how the whole thing would originate against the ship. Hence, if you read Barge Madhava, in that interplay between IBC and maritime jurisdiction, because when under IBC, not many would have, I don't know whether, because you don't have NCLT here, the scope of practicing under the Insolvency and Bankruptcy Code also is limited. Section 14 of the IBC provides for a moratorium once. It is similar to Companies Act the Munnadi. Winding up 434 notice கொடுத்து நீங்க petition file பண்ணுவீங்க, where the registered office of the company is here, then you may file here also. Similarly, so once a petition is admitted under the Insolvency and Bankruptcy Code, a moratorium automatically kicks in. So no suit, no action can be filed against the company for a period mentioned. So in Barge Madhava, I went, that was a problem. Crew members' wages are not paid. You can't, the ship comes, ships will go away. You can't. Indian ship owner, ship will sail away. Ship will never come to India. She will be sailing between Dubai and Italy or somewhere, or Switzerland, Germany or wherever. So I held the IBC, the moratorium is against the company against whom the petition has been admitted, whereas the Admiralty suit is against the ship. Not an asset of the company, but ship as a person. And therefore the moratorium won't kick in. These are all finer nuances. You will have to sit peacefully and then read it. But having said this, the Admiralty, when he also mentioned earlier, we were following the old 1841, 61, 91, etc. And therefore the 2017 Act came into force, which says, an act to consolidate the laws relating to Admiralty jurisdiction. An act to consolidate the laws relating to Admiralty jurisdiction. So the law had been laid everywhere. You will find primarily in judgments. So you have to put everything together so that it becomes easier for any claimant, any court, any defendant to deal with a particular situation. So here there are two kinds of actions which is contemplated. One is action in rem and action in personam, that everybody would have heard about. So when I said in the beginning that the ship action is against the ship, correct? So it's an action in rem. Once will the ship come and defend? There is nobody to defend. The moment you arrest a ship, traditionally, expectedly, the owner comes in and files, furnishes, before enters appearance. Owner will come and say, hey, that's my ship, you have arrested. But he has to go and tell the court. because that court has passed the order of arrest. So when he does, how does he do it? நீங்க என்ன பண்ணுவீங்க? உங்க கிளையண்ட்டுக்கு சம்மன்ஸ் வந்தா முதல்ல போய் வக்காலத் ஃபைல் பண்ணி விடுவீங்க. கரெக்ட்? So when you file wakalatnama, you are submitting to the jurisdiction of the court. Of course, you may reserve your rights to challenge without prejudice, etc. So by you submit to the jurisdiction, the moment you submit to the jurisdiction, of course, I have also held that if no security is furnished and you furnish then security to allow the ship to sail, it becomes an action in personam against the owner. If the owner does not come forward, then the court will take steps to sell the ship by way of a public auction. In Bombay, it is done through the sheriff's office, the auction. The sale proceeds are then kept in the court. The court becomes custodial aegis. The Admiralty registrar becomes the custodian, and then a notice is issued in the paper saying that the ship is arrested, sold, sale proceeds have come. If anybody has any claim against the sale proceeds, come here. So when all claimants come, whoever has a claim against the ship or the sale proceeds will file independent action. Rules provide for each party to intervene in the other one, because he will want to bring down the other man's claim. If no owner comes forward, each claimant will try to fight against each other so that there is maximum money left in the kitty for distribution. And then the priority is decided by the court. Who gets first how much money is then distributed. That's how normally the whole thing, the system functions. Now, which court? All high courts don't have jurisdiction. There are 8 courts mentioned in section 2 into bracket E. 1E, 2(1)(e) is High Court of Calcutta, Bombay, Madras, Karnataka, Gujarat, Orissa, Kerala, Hyderabad for the state of Telangana and the state of Andhra Pradesh, or any other court as may be notified. Only these 8 courts have. So hence I said there is something, this is food for thought for all of you, particularly the younger lord, to see whether they can drag some work out of Madras, the principal seat, to Madurai. Examine. It is something which is worth examining. Because Tuticorin, as he mentioned, has got over 600,000 TEUs movement. TEUs are 20 equivalent units. These are all standardized containers, 20 units, 40 units. There are 20 feet, 40 feet. These are standard sizes because you can't have different shapes. Because ships will all have been built with these standard equipments in mind. So when there is if there is scope, not only TEU, the container movement, but also bulk movement, maximum of bulk grains also come to Tuticorin. I can tell you another story on that, but we won't have time to go through this in a matter that I was involved. So then it goes from here. So then how does the jurisdiction come in? If you have the subject to provisions of section 4 and 5, the jurisdiction in respect of all maritime claims under this act. You can't have maritime claims somewhere else. Certainly, Commercial Courts Act mentions about maritime claim also is a commercial matter. Correct? No, nobody knows. Under the commercial courts, a district judge can exercise jurisdiction in a commercial matter. Correct? 3 lakhs or 1.5 now. Has it been reduced? No. 3 lakhs. Can he arrest a ship? No. Because one, it says High Court will exercise jurisdiction. And then, and be exercisable over the waters up to and including the territorial waters, up to and including the territorial waters of their respective jurisdiction in accordance with the provisions contained in this Act. So therefore, Madras, within the territorial waters of over which it has jurisdiction, Bombay, etc. So the luxury that we had of lawyers running all over the country getting ships, arresting ships is no more available. So if the maritime lawyers, there is a new crop of maritime lawyers coming up in various jurisdictions. So therefore, what is Section 4 talks about now? Maritime claims. The High Court may exercise jurisdiction to hear and determine any question on a maritime claim. The High Court may exercise jurisdiction to hear and determine. In fact, I was thinking about Sharat Chandran. It says determine any question on a maritime claim. It doesn't say any maritime claim. Why the words question on a maritime claim? Why has that been? It was something which struck me last night. That's the way you lawyers should think. I said that only to kindle your brain, just to make you think. Why? How you interpret, how you read a section this is the way you must think. No word is superfluous. No word is a waste. Why did they use may exercise jurisdiction to hear and determine any question on a maritime claim? It does not say determine any maritime claim. You follow why that's how you should all think. You may have an answer. We would love it. And I should tell you, sir, why I said it is my open offer in Bombay, because I live in Bombay, to all the youngsters, no fees. You have any matter you don't know how to handle, come to me, I will guide you. Because that will also help me. Yenna vela pannalaina thalassoru settu poidum. இன்னைக்கு எல்லாரும் AI ன்னு சொல்லிட்டு இருக்காங்க. Buddhi is the only organ which grows with usage. It improves with usage. Please use your brain, God-given brain, and rely the least. Yes. What is the reference citation of MV Elizabeth? You type. That is also AI. That is quick. But is there a law like this? Do it. But not for anything else. You're killing yourself, your brain, because when you rely on AI, how to draft a petition, they are now talking of use AI. How can you use it for leading evidence? You can't. Anyway, that's a separate aspect. So the claim against any vessel, the High Court may exercise jurisdiction to hear and determine any question on a maritime claim against any vessel arising out of. It doesn't say for. It is spreading it wide. Arising out of any. There is up to W. 23 items are there. And 23rd I will spend a few minutes with you, which is also interesting and peculiar to maritime jurisdiction. A dispute arising out of any dispute regarding the possession or ownership of a vessel or the ownership of any share therein. Traditionally, a ship is divided into 64 shares. So there could be disputes between the owners. Co-owners, mortgage, loss of life, or injury occurring on land, water, etc., in direct connection with the operation of a vessel. You would think, why land? In the port, when she is coming alongside, if she hits one of the crew, port staff may get injured, or a cargo handler may get injured. Therefore, loss or damage to or in connection with any goods, it's so widely worded. It can be goods carried on board. It can be goods carried in case of a collision. Modradilya, car accident, lorry accident, mari kappallu tannila accident agum. ஒரு மாதிரி அது ஆக்சிடென்ட் வந்ததுன்னா அது ஹேண்டில் பண்ற லாயர்ஸ் எல்லாம் புது வீடு வாங்கிடுவோம், புது கார் வாங்கிடுவான். Because that's the kind of stake involved. And all of that, another thing, just to digress from the claim, he mentioned about insurance. There is something called protection and indemnity clubs. They are the mutual insurance association. Ship owners come together and mutually insure. And the premium they call it as call money. These clubs also give a FD&D cover. That is freight, demurrage and defense cover. The rest, freight and demurrage, you would assume, you will know. Defense, legal fees are also paid by these insurance companies. So 90% of the maritime lawyers, 90% of the income come in US dollars. Because it is all funded by the club. Subject to, of course, you having like an insurance cover that you will have. So I'll spend a few minutes, 5 minutes more for that, because these are the standard claims which you would come. So I wouldn't spend time, we don't have much time for that. I would have loved till 8:30, but the general claims which comes in a maritime dispute. Can you guess? First, cargo damage. Second could be wages. Third could be insurance claims. Four could be collision damage. 5, and which is one of the big business that you will see, is salvage claims. If a ship is in distress with cargo on board, there are salvaging companies who offer professional help. I did one matter for a vessel called MV Roshni in 96 cyclone. Navy rendered assistance with sorties being sent, the ship's batteries, everything died. They lifted in helicopter, batteries, lowered it into the ship and then towed her to the port. So Navy made a salvage claim, because but for my act of bravery in trying to protect the maritime property, it would not have survived. And that maritime property includes the ship, the cargo, as also the freight which the owner would have earned, and each one contributes to the salvage cost in proportion to the benefit they have derived from the act of salvage. Understood? And the law says substantial. You must encourage, be generous in giving compensation, and these are all paid by the hull underwriters or the insurance companies. So that is one part. Another most important which happens is the ship financing, mortgage. The ship is who are funded, then you will have claim for towage, pilotage, as also for repair costs, supply of bunkers. So these are the claims which you will have against the ship, and then you move against the ship, get an order of arrest, and then take the matter. Once security is given, of course, priority, everything is determined like here, but otherwise it will follow the same procedure as anybody will follow in any other court. So then the final W which I mentioned, 23rd, maritime lien. Maritime claim includes maritime lien. All maritime claims won't be maritime liens, but all maritime liens will be maritime claim. And the peculiarity of maritime lien is it goes with the ship. Of course, our act has restricted it to 1 year limitation. What happens is, if you have a maritime lien is available for a claim for salvage, collision damage, crew wages. Then there is respondentia and bottomry, which nobody talks about. Those are all of antique value. Let's say you have a crew claim. Crew wages have not been paid. The crew member has been discharged from the ship. Hey, he keeps writing, sir, you have to pay me 20 lakhs of rupees, my wages you have not given me. By the time he decides, he also must be sailing in some other ship. By the time he comes to the shore, this man has sold the ship. So for a maritime claim, section 5 then it comes to, the 5 says, a person who owned the vessel at the time when the maritime claim arose, that is when the crew member's claim for his wages arose, should be liable for the claim and is the owner of the vessel when the vessel is arrested. So the same owner should be the owner when he is moving for arrest of the ship to make his claim. But before he makes, the ship is sold. Poor man, where will he go? It was a one ship owner. He doesn't get his claim at all. So therefore, maritime lien helps. Even if it is sold and the new purchaser of the vessel is an owner purchaser in good faith with no prior knowledge of a prospective claim, still he can go, and that is maritime lien. But that relief, that right is not given for all claims. So therefore we said, all maritime liens are maritime claims, but all maritime claims are not maritime liens. This luxury which a maritime liener has, is not available to somebody who has supplied bunkers or whose cargo is damaged. This is not just the act. Reading this, I am going to now take another. That luxury he doesn't have. And now if it is an Indian ship is sold, he comes as an operational creditor under the Insolvency and Bankruptcy Code, and the banks will take away the sale proceeds. Read Baj Madhwa. This will also give you an idea how to go about. Because, so therefore, this is how you proceed. This is how maritime claim and maritime lien is the difference. Then he also mentioned in the passing about sister ship. He mentioned about Elsa, and he mentioned about the damage, coastal damage that happened in Kerala. Read State of Maharashtra versus MSC Clementine. That's my judgment from Bombay. Where the state filed a suit on a parents patria principle. கேட்டிருக்கீங்களா மதுரையில் நீங்கள் எவ்வளவு? The king is the father, parent of the subject. So the state has filed a suit to recover the loss. That was a case where two ships had collided containers had fallen off, some containers containing hazardous cargo, fishermen lost their livelihood, damage to environment, and therefore I as a state on behalf of the fishermen, we have filed the suit. That was at the interim stage I heard, but it will give you an idea how these unique matters come up. How unique, how the brain of a lawyer works to bring up a claim. Summa file panna mudiyadhe. These are all to make you think, how can I create? Vakil vandu, we all are manufacturers, not poye. We all create. We are really artists. We really create such ingenious arguments. I can't talk about it in the afternoon. Some matters we were all discussing and we came up with such arguments and points. Even we were surprised. Oh, you can still, you are not rusted yet here. So therefore, there is something called, which is unique, called as sistership. That's provided, the Act provides for it, Section 5. Because what is unique under the, see, this is why you need to know not just the law, you need to know how the business functions. இப்போ நீங்க ஒரு லேண்ட் கேஸ் பண்றீங்கன்னா தெரியும் இல்லையா, அங்க என்ன நடக்குது, தஹசில்தார் ஆபீஸ்ல என்ன நடக்கும், அங்க இது வேணும் அது வேணும்னு. அது மாதிரி there are a lot of nuances which you need to know. Because a ship can get arrested for a claim against the ship, I have said in a judgment, MV Hartati, 2013 or 14, where, what is wrong? They said it's a fraud, it's a cheat to cheat. I said, orally simply saying is not enough. The trade permits you to have different ships. இப்போ டூரிஸ்ட் கார் நடத்துறாமா, 10 கம்பெனி போட்டு 10 கார் வாங்கி வைக்கிறான், என்ன தப்பா? அது same way. So how do you go against the owner? So hence they provided for sistership. In case if a ship may not even come, take for example your claim under the Carriage of Goods by Sea Act, when you come, the claim limitation is 1 year. Cargo damage, ship has sailed, she is not going to come back, or she has been sold, or she has sunk. How do you claim against the owner? Then it provided for, so that owner, if he has one more ship and it comes within the jurisdiction, move for arrest of the sister ship. What is a sister ship also has to be seen, because every ship owner is different, charterer is different. Charterer is hire பண்றோம். நீங்க 2 கார் வச்சிருக்கீங்க, ஒரு கார் உங்க ஓன், ஒரு கார் நீங்க ஹையர் பண்ணி ஓட்டுறீங்க, சிஸ்டர் கார் ஆகுமா? ஆகாது. ஏன்னா அந்த காரை நீங்க பிடிச்சு வச்சீங்கன்னா நஷ்டம் யாருக்கு? இந்த ஓனருக்கு இல்ல, அவனுக்கு. So therefore sistership also is a very unique concept applicable to the Admiralty jurisdiction. Then it provides for section 6 talks of action in personam, then collision personam, how all you can do it, then vesting of rights on sale of vessels. This is something again unique here. You all know surface எவ்வளோ மேட்டர் பண்றீங்க இல்லையா? மேண்டமஸ் கொடுங்க, பேங்க் ஒன் டைம் செட்டில்மெண்ட் அக்செப்ட் பண்ணணும்னுட்டும் ஃபைல் பண்றீங்க. Correct. You are making, your client is giving you instructions, you are doing nothing wrong. But when the bank sells the asset, that's a court sale. Here, under the Admiralty jurisdiction, on the sale of a vessel under this act by the High Court in its exercise of its Admiralty jurisdiction. If a High Court sells being an asset of an Indian company, this section may not help you. Because it says, in exercise of its Admiralty jurisdiction, not in any other sale. The vessel shall vest in the purchaser free from all encumbrances. So, attachments, registered mortgages also, and charges of the same nature on the vessel, so widely worded. The moment the court has arrested the ship and the ship is sold and the sale proceeds come in, every claimant, you name bank, anybody under the sun, including a maritime lien holder, will have to come to the court and make a claim on the sale proceeds. So because it is sold free from encumbrances, you cannot rearrest the vessel for any claim which was available before she was sold. Afterwards it doesn't matter, because again that claim will be against the new owner. So that is something which is interesting and peculiar to section 9, section 8. Then 9 talks about inter se priority. Every maritime, on maritime lien holders also have inter se priority, and that goes the salvor. He gets the highest priority because the last salvor, because he is the one who has protected the asset for the benefit of everybody. Hence, நான் தான் உன் கப்பலை காப்பாற்றி கொடுத்தேன், முதல்ல என் கிளைம் கொடுக்கணும். என்ன நான் இருந்திருக்காட்டா யாருக்குமே ஒன்றும் கிடைச்சிருக்காது. So pay me, okay, you negotiate for a proportionate haircut, etc. That's what is used in the banking parlance. You take a haircut. Correct. So how much, how big is your haircut? That's how they talk. So that is, the priority is also decided. And here in the priority point I would mention about the IBC, because under the IBC the priority, everything goes to the committee, the banks, the financial creditors. The operational creditors and other creditors get some crumbs. But under the maritime jurisdiction, Admiralty, under this act, the priority is different. The crew members take the money, port takes money before the bank comes, they are coming some number 5 or something. Hence in Barge Madhva, because under the IBC there is a non-obstante clause saying notwithstanding any provisions, this will prevail. And law says if there are two views, the specialized act will prevail. We said there is no contradictions. Purposeful interpretation has to be made. The acts have to be read together. There the claim is against the company, here it is against the ship. Hence, there is no contradiction. Priorities, because banks also, here the sale is free from encumbrances. So when it is free from encumbrances, what happens? You get more bidders. Correct? If you are selling your car and onnume illa good car, you will have 10 buyers coming in. But you say, a few accidents it has happened, I don't know what are the claim, nobody will come. But okay, I don't know, you are buying, that you will have to handle, I won't even indemnify you. Nobody will come. So because it is a sale free from encumbrances, you get more buyers and better offers. So that is the beauty of this jurisdiction, Admiralty jurisdiction. Then order of priority, 10 talks about priority, then application of CPC, etc., assistance of assessors, which you can do like you have in under the Commercial Codes Act. You can use assessors, and then repeal, etc., he mentioned about it. So having said that, we need to not just restrict ourselves, because the head is maritime claims. Correct? So when you have a maritime claim, you can't, the claim is not under this act. This act only tells you what you can do if you have a maritime claim. But how meritorious is your maritime claim? For that you need to know other peripheral provisions of law. Okay? One of the most, before you go into that, is ships. Unlike, I'll make it simple for you all to understand. There are three kinds of hiring of ships. Ship owner need not, A may have a lot of money, he buys ships. Like MSC Clementine, MNC we mentioned, they don't own any ships. Their way of business is hire ships. And every ship is hired by a different company. And what I am told, I do not know, don't quote me, I mean, the accuracy I am not aware. They say after 2 voyages world over, they will sell it away. They have made the money which they have invested for paying the hire. So there are 3 kinds of hire you have. Voyage, charter party is an agreement. So if somebody uses charter party agreement, the word agreement is superfluous. Charter party is an agreement. There are 3 kinds. One is voyage charter party, 2 is time charter party, and 3 is demise or bareboat charter party. Okay, these are the 3 things. I would assume many may not have even heard of these expressions. Correct? But this is no rocket science, nothing to be scared of. You are hiring a taxi from the High Court gate, or hiring an auto rickshaw from the High Court gate to go to Madurai Meenakshi temple. What is that? It's a voyage. From Madurai High Court gate to Meenakshi temple, it is a voyage. That is voyage charter party. You are not the owner of the auto. Owner is the driver or the one who is somebody else. You are not concerned. You get in, meter down, you pay. You reach, petrol is filled by him. If he jumps a signal, he pays. Parking charges, he pays. Everything is paid by him. So that is the easiest way of understanding what is a voyage charter. 2 peculiar things which also arise in that. Demurrage and lay time. Adu rocket science. Late time na ennadu, demurrage na. Sir, evlo neram edupinga sir, waiting poduven. Correct? Sir, neenga evlo neram mele irupinga, allata waiting kedaikum. Illappa, na 10 நிமிஷத்துல வந்துடுறேன். அதனால உங்க freight மீட்டர் வந்து நான் 100 ரூபாய் தான் வாங்குறேன். நீங்க 3 மணிக்கு உட்கார போறீங்கன்னா 150 ரூபாய் வாங்குவேன். So he fixes the freight for you based on, or the fare for you based on the time his vehicle is available only for you. Otherwise, if you say I'll come in 5 minutes and wait for 3 hours, he is losing 3 other passengers. So that time which he has to use to load or unload the cargo is the time called lay time. How? What is the time my vessel will be laid there? That is lay time. Then he says, all right, I am giving you 2 days from the time notice of readiness is issued. Everything is, and there are other details which, like he said, what we are talking today, we can go for 6 months, have a class, lecture. I'm serious. I did it for study for 1 year, sir. London la pay. So you have to pay. What you have demurred to pay will do, and you don't is called the demurrage. So that is the liquidated damages. In short, when you tell the auto fellow, I will come within 1 hour, but if you exceed 1 hour, for every hour I will charge you 50 rupees. That is the liquidated damages you have assumed is a reasonable loss that he would suffer because of you detaining the vehicle. Correct? So this takes care of voyage charter, time charter. நீங்க வந்து பெங்களூர் போறீங்க, அங்க இருந்து some அந்த hill resort இருக்கே, அல்ல forest resort, not Hubli, Coorg போறீங்க. So you go to, I've heard of that, Zoom cars, I am not propagating them. You hire a car, 1 week, either self-driving or with driver for 1 week. You are hiring with driver, without driver. That is called time charter party. So in that, either by default you will be filling the petrol, correct? He'll give you full tank, you give back full tank. The driver's salary is paid by him. Parking charges you have to pay. Toll you have to pay. Correct? So these are the peculiarities of time charter party. Of course, they will also have trading warranties. Sir, கூர்வுக்கு தானே போறீங்க சார், அங்கிருந்து ஊட்டி போக கூடாது, நீங்க இந்த ஏரியால தான் இருக்கணும். Those are trading warranties. In time charter party, the charterer, that is the hirer, will give on voyage charter to somebody else. Ships are not like you going in a car for a family holiday. He is using the ship to carry cargo. Time charterer need not, like for example, Indian Oil will hire a ship, a tanker, for 1 year because they are importing so much of cargo. But all need not, like a container vessel, he need not carry his own, he will carry containers from different people, so he will give it on voyage charter. The third one is called bareboat or demise. Simple. நிறைய பேர் கார் ஹையர் பர்ச்சேஸில் வாங்கியிருப்பீங்க, அதுதான். So the whole Admiralty law, Maritime law, I have made it simple. So you all can soon, like he was saying, spend some time with him and then become maritime lawyers. The other part, the third is goods, is what is the primary claim. Ships are used for carrying goods. So which are the two provisions of law that applies? Carriage of goods by Sea Act and Bill of Lading Act. இப்போ நம்ம சார்ட்டர் பார்ட்டி சொன்னோம், கப்பலில் கார்கோ லோடு பண்ணிட்டுனா நீங்கள் ரெசீட் கொடுப்பீங்களா, லாரி ரெசீட் கொடுக்குறானே நீங்கள் லக்கேஜ் மூவ் பண்ணுறதா, பஸ்ஸில் இறங்க டிக்கெட் கொடுக்குறான் இல்லையா, அது மாதிரி ரெசீட் கொடுப்பான். The document used is called a Bill of Lading. It's a document of title. It is a transferable document, not negotiable document. It does not give you a better right. And it is a receipt. So these are the three functions of a bill of lading. Correct? So now Carriage of Goods by Sea Act has got 1 year limitation, then with the amendment 3 more if the owner agrees. Plus it also has provisions for limitation of liability. The owner may say, I will limit my liability based on the cargo, weight of the cargo at 666.666 special drawing rights, SDRs. Article 3, Rule 6. No, 5. 6 is for limitation. So these are the peculiarities of the Carriage of Goods by Sea Act. So by receipt issued is a bill of lading. Okay? So let's take an illustration. Mr. A in China is selling iron ore to Mr. B in Madurai. Or let's say computer chips. A does not manufacture. That is manufactured by C in Taiwan. So A is the seller, B is the buyer, C is the shipper. So who gives the goods to the ship owner, the master? C. So the contract is with whom? C. C gets his money from A under a letter of credit. Those things again, I wouldn't go into the details. Goods come here. Mr. B sitting in Madurai, he finds that he can get better price because computer chips market has come down, availability has come down. He sells it to Mr. X sitting in Ahmedabad for a huge margin. So who goes and takes delivery of the goods? X. There can be high sea sales, there can be after delivery sales also. So these are all the nuances of this subject. How much detail and you need to look into. Contract is with C, goods come to Mr. X in Gujarat. He finds the goods damaged. The container has had water ingress, salt water, and the chips have got damaged. So he will make a claim from the insurance company. Insurer will, rights are subrogated to the insurer. He sues the ship. Correct? How will he sue? He will show the bill of lading. This is my cargo, I have paid for it. You have issued the bill of lading. Therefore, and you have caused damage to my goods when it was in your custody, and hence you have to pay me damages. Correct? That's how everybody will do. But the Bill of Lading Act does not say so. There is an amendment in 25. They have retained the old provisions of the 1856 Act. And it says every shipper, he has a contract with the ship owner. So it says every consignee of goods, because shipper has got his money, he is not interested in suing. Every consignee of goods named in a bill of lading. If you see a bill of lading, it's all documents. We should have got those, the samples of this and distributed. Consignee, because there could be named consignee. Shipper is C. Consignee will be shown as B, because he is the original buyer. Or B would have borrowed money from State Bank of India and paid through the LC. Tomorrow goods comes, he won't pay the bank. So the consignee could be to order. Whose order? The one who endorses behind. Or to order of State Bank of India, because State Bank of India has to recover its money, no? So they can tell who it will go to. So every consignee and every endorsee. Now comes State Bank of India's name is, because of B, A, C has shipped the goods. He has to be paid by A in China. He forwards the bills of lading and LC documents to A's bank in China. From A's bank will forward it to State Bank of India. And State Bank of India will give it to B. And B will give it to X. And that transfer happens, I said it's a transferable document that happens by endorsement on the back of the document. A bill of lading idu mari oru paper da. One side all details. Now a lorry receipt also everybody would have seen. Similar document. I mean, let's not try to make this rocket science. And the back will have the terms and conditions. It's called the reverse will have the terms and conditions. And here they put an endorsement. So by simple endorsement you can write X or blank endorsement also, so that X can sell it to anybody else. So the endorsement happens and he takes delivery. But here the section says, or and every endorsee of a bill of lading, not any other document, to whom property in the goods therein mentioned shall pass. To whom the property in the goods mentioned therein shall pass. How? Not by simple. Upon or by reason of such consignment or endorsement. So only if a property passes upon or by reason of such endorsement, that endorsee, not every endorsee. So State Bank of India is an endorsee. But has a property passed to State Bank of India? No. Under the Sale of Goods Act, when does a property pass? When the parties intend to pass. But bank and its client, there is no intention to pass property. It's only to give security. And that should pass upon or while endorsing, upon or by reason of endorsement. If goods are delivered and the bill of lading is endorsed later, property passes, but it is not, property has already passed. It is not upon or by reason of endorsement. Delphini is the name of that ship. This main thing which I am talking is Aliakmon 1984 House of Lords. So if only such a person can sue. Now you realize the problem. When you got the chance to amend the law, England amended it in 1999. I don't know why our lawmakers, sir, did not take this golden opportunity to rectify. You follow what I am saying? So these are the very fine points which thrill you won't get in any other subject. This kind of interpretation, interplay between the words, you will never get anywhere. Similarly, so under the Bill of Lading Act, and then you have the Multimodal Transportation of Goods Act. Bills of Lading Act applies where there is port-to-port shipment. Then you have Multimodal Transportation of Goods Act where, as the word says, more than one mode of transportation. Like you will be taking it from one of the container freight stations here of near Thoothukudi, take it to Madras, Ennore Port, and Ennore Port. So the transportation is from here by road and from there. Otherwise you also have this Tughlakabad and near Delhi, all those container freight stations where Concor, container corporations, there are some other canalizing agents who move by train to Kandla port, and then from there the goods are loaded. So there are, or you take the goods to Houston, and from Houston you are driving the cargo into the interiors to deliver. Now under the Income Tax Act, I came across a situation, I framed the question of law. Under the, under the income tax, there is double taxation avoidance agreement between countries. So you don't pay tax in both countries. Shipping is one such industry which is included. Now this, I mentioned about CFS, Container Freight Station in Tughlakabad to Kandla. Some shipping lines give value addition. I'll come to your factory, pack the goods, bring it to the CFS, because transportation shipping has to be from one customs area to another customs area. But they have carried it before it enters a customs area. Whether that leg between the factory to the container freight station will be shipping business. That's a question of law I had framed, and then I came away to Madras. See, therefore, these are all, I am saying it to make you all think, why not this practice also, maritime practice. I'll just rush through. Then comes, we mentioned briefly marine insurance. Marine insurance has the provisions for not, like any insurer, utmost good faith, make all disclosures, what is material fact also matters, and Naraya case, and then you have total loss, constructive total loss, like your car, if it is a total loss, if it has caught fire, you will declare it as a total loss. But if it has met with an accident and the cost of repair is more than the insured value, you will say the car is existing. But it will be a constructive total loss. To retrieve the ship or make it ship seaworthy, the cost is going to be bigger than the insured value, then you will declare SCTL, they call it, constructive total loss. Then Customs Act. Customs Act provides for goods to be loaded and unloaded into India and out of India only from a customs area. So when you bring ship into India, you will have to declare, no, நீங்க வெளியூர் போயிட்டு வந்தீங்க சொல்றீங்க இல்லையா பேக்ல என்கிட்ட இதெல்லாம் இருக்குன்னு. Same way the ship has to declare. Who declares? Under section 30, the person in charge of the ship, that is the master of the ship. He declares, ship comes and goes away, you come and live here. So he has to declare, I have carried 100 bags, I have unloaded and I am going. So the customs persons will give an endorsement, okay, go. But under section 42, he cannot go unless he satisfactorily accounts for the 100 bags. But if he has to satisfactorily account for 100 bags, he will be stuck there for 2 weeks. Our Sonare, 2 days turnaround time today. And in that, overnight we would move the judge's house, we would move on weekends, because if it is arrested on Saturday morning, she is fully loaded, she has to sail Saturday night. We will rush to judge's house. Please get release the vessel. This is how do you give security? I have done in one matter, because banks are closed. We given property documents of the owner. Bank தொடர்ந்து பெரிய பார்ட்டி பேங்க் தொடர்ந்து சண்டே பேங்க் டிராஃப்ட் இஷ்யூ பண்ண வச்சோம் 5.5 கோடி ரூபாய்க்கு. இதை வச்சுங்க 3 நாள்ல பேங்க் கேரண்டி கொடுக்குறேன், இதை அப்போ ரிட்டர்ன் பண்ணுங்க. If we don't give, you deposit. See, these are all ways to take care of the interests of your client. சார் முடியாது சார் அப்படிதான். No, you have to run the extra mile to retain your client. You're charging fees, deliver, charge more. I have to do it, but deliver. The client comes to you hoping to get justice. You have to deliver. And then comes the Customs Act. Then, so what happens? 42, the ship sails away. So the agent of the ship who filed the import general manifest will give a bond to the President of India. I will undertake to account, and if there is a shortage, I will pay the penalty. Because you are supposed to have moved the goods outside to avoid paying customs duty if there is a shortage. So that's how the agent comes in under section 148. He gives an undertaking. Then you have 112, 15, etc. for carrying goods which are not to be done. Merchant Shipping Act has got two interesting provisions. One is, the new section is 162, 63, limitation of liability. If there is a collision or a ship sinks, there could be loss of life, damage to cargo, loss of cargo, loss to ship, another ship, port collision, there is loss. If a ship sinks in the port, next 3 months no other vessel can use the port because they have to lift that ship to make clear the passage. Idu mari 4-lane highway angala kadakiyadu. You have there it is like the old national highway, 2 lanes. So the owner can set up a limitation fund based on the tonnage of the ship. That's very peculiar under the Merchant Shipping Act. And that fund, everybody has to go against that fund. I think MV Elini is the name of the ship. My judgment. You may just run through it, you'll get some idea of that. And then it has also called for marine inquiry. If there is a maritime casualty, there is a marine inquiry conducted by a person not below the rank of the Additional Chief Metropolitan Magistrate. They use 2 or 3 assessors, naval architects, master mariners, marine engineers to assist the court. It's a fact-finding inquiry. It's not basically to put the blame, he is responsible, fact-finding. They give their opinion subject to challenge. And then you have the Major Port Trusts Act, because when you bring the goods to the port has to be governed. They have to receive, because customs say only this place I am agreeing to be a customs bonded area, customs area. So Major Port Trust Act comes, 42, they take charge of the goods and then give the goods. Owner does not deliver the goods. The ship does not deliver the goods. The ship discharges the goods in the port, and the consignees, clearing agent goes with the original bill of lading to the ship's agent. I am talking of simple, straight things. Who will receive original bill of lading, make a photocopy, put a stamp behind it, order to the port, give delivery to the holder of this document. That's called a delivery order. So he will go to the port manager, show it with his truck, take the goods away and deliver it to his customer. So that's called a delivery order. So when goods are gone, sometimes goods are not cleared. There could be a fraud, or the ship consignee ceased to exist, or there is a dispute between the consignee and the shipper. He has not paid. He says, I don't want the goods. Na tuka mata. It can happen. So what do they do? Goods will lie there, no? The warehouse keeper is suffering losses. The port is a warehouse keeper. So under 60, 61, 62, they have provisions to sell the goods. And once sold, if there is a deficit in sale proceeds, they will go against the ship owner. Under section 2O, owner agent is included. This I'll have to spend 2 minutes. It's interesting. It was my baby. 4,350 rupees was the claim. 2 rounds to Supreme Court. Client said blank check, fight, because that had long-term repercussions. Losing that matter would have been straight away poorer by 25 crores. So we won first round, not won first round. First round we succeeded in showing a 5-judge bench was not correct. 3-judge bench got it referred to a larger bench. They said no need to refer. Back. Then went to another who wrote against us. Then we had succeeded a matter in Kerala High Court before Justice Chalameshwar. That went to again Supreme Court. All the lawyers who appeared became judges also in those matters, even in Kerala. And then when it came before Justice Chandrachud, he said this is a nagging matter, requires to be settled, and passed a referral order. And then it came before Justice Nariman's bench. And he said, an agent of a ship owner cannot be called the owner of the ship cargo under section 2O. Therefore, you can't. The problem was the agent cannot clear the goods because he is the ship's agent, not the consignee. If the port tells you clear it, he can't. Customs won't allow him. You re-export, he is not the importer, he cannot re-export. So you have tied his hands behind and telling him to fight. How does he? You follow? These were the issues involved. Very interesting points that would come up. Then having said that, Major Ports Act, then Indian Ports Act, section 14, when the ship sinks in the port, you have to remove. If you don't, the port will remove and claim the cost plus 20% of that. So these are the provisions of law which then, of course, most importantly, I missed out. Upon or by reason of endorsement, I said when we were discussing Bill of Lading and Carriage of Goods by Sea Act. Correct? When does a property pass? When parties intended to pass. When can a property pass? If the goods are ascertained. Only in ascertained goods property can pass. Ascertained means I am identifying this as the good. Property has passed. Correct? Now, if the ship is carrying 12,000 tons of wheat in bulk, there are 6 consignees. Is the wheat ascertained? Whose is which wheat? No. It becomes ascertained after you discharge and deliver. புரியுறதா? கோடவுன்ல 12,000 டன் பேக் வீட்டு வச்சிருக்கீங்க. யாருக்கு யார் வீட்டு தெரியாது. நீங்க போறீங்க, என்னப்பா 10 பேக் நீங்க எடுத்துங்க. நீங்க போறீங்க, என்ன 10 பேக். 10 பேக் கொடுத்தோம்னா அது அசர்டெயின்ட் ஆயிடும். Correct? So in such a situation, how can property ever pass upon or by reason of endorsement? Because goods are not ascertained. These are all very, very interesting points which you will come across in this field of litigation. There are other fields also which are very interesting. But in this, these are the kinds of issues which you will come up. I'll just mention Continental Lotus inquiry, marine inquiry. A witness came and said the ship was unseaworthy. Cross-examination of that witness. We proved that whatever he was saying was hearsay evidence. So you need to know. Evidence Act has also trial work. Then there was quite a few matters. Just one last matter I'll mention, Alondra Rainbow, which was a ship piracy matter. Another problem which you have, particularly in South China Sea and when Somalia was also there, piracy. Ships were getting hijacked. So I worked for the prosecution team and we got 14, one died, 14 Indonesian pirates, 7 years RI. So, such interesting matters you come across. So, leaders of the bar and future leaders of the bar, this is a very, very interesting field. The Madurai Bar Association, in collaboration with the Gujarat Maritime University, has set the ball rolling. It's a good beginning. Keep going. I would request the President, Venkatesan, everybody, the office bearers of this bar, and those who are not office bearers of the bar, members also, to keep this process going. You started with maritime. There are so many other fields. Arbitration law, correct? He mentioned about why not arbitration, why should you file a suit? Arbitration, you can't get a ship arrested. So that's the advantage. So these are all issues which will come up. Academic interest, you can even, I had organized on commercial call Mr. Sharat Chandran, your old man who comes to Madurai very frequently. His last edition on commercial contract law, I wrote the foreword. Ask him to speak on commercial law, because these are all the growing field. How long can you, we have to think big, we have to grow out, come out of the shell, then only you will grow. Not just, I'm not talking from money perspective alone. You get this intellectual growth, intellectual stimulation. So have those classes on a regular basis. Bombay Bar Association has it every 2 weeks. In fact, I don't know whether did they do it in Madurai. I had set the ball rolling in Madras, principal seat. Bombay lawyers with lawyers from Malaysia all came for a training session for young lawyers, one-to-one, including on art of cross-examination, art of trial, pleadings, everything. I said, when I was the chief, I said, I'll organize even in Madurai so that even the Madurai bar can benefit. Just check up Bombay Bar Association. I'll give you the president's number, and you just contact them and get these things done on a routine basis so that everybody benefits, everybody share their knowledge. Okay? I would have loved to throw the floor open for question and answer, but can we give 5 minutes? It's only 10 to 8. 10 minutes? The academic opinion for you personal, we will sit together, but please ask a question which could touch upon, but which could benefit the participants here.
One thing, we had that express vessel which was some satisfactory and between Sri Lanka and India.
So in that particular matter, the Sri Lanka court, they gave a award that the insurer must pay $1 billion US in compensation, which the London PNI openly denied that we will not pay any single time for this. It's an unsubstantiated judgment. Now in this matter, so if a similar situation occurs in India, and does the court have the power to direct that this insurer is an unreliable insurer and as a consequence of not compensating?
That very difficult to answer. If I have power, of course I have the power. But is the power rightly exercised? Will I have jurisdiction? Those things will certainly have to be factored in, and to take a decision is a very tough job. And various factors will also be considered, whether they were given an opportunity to be heard, whether they participated, whether evidence, given an opportunity they did not participate. Any court will say, I gave you a chance. But that does not mean in such complicated matters you will pass an order of a rule 8 order.
Because there is no sister vessel, there cannot be a sister vessel.
No, I am not talking of sister vessel. Your question was, can the insurance, the London club, PNI club or the insurance company can be castigated? It all depends on facts and circumstances of the case. Without reading the order or judgment, very difficult, and it is inappropriate for any person to say that court was wrong. Whether India, why should India exercise jurisdiction? The PNI is not here, cause of action did not arise, order is not there, nobody has come here for execution. Why should court will say, sorry, I don't have jurisdiction? Possible. These are all various factors. So these are all factors, doctors.
Particularly, yes. So now consumer forums are also taking such matters, and in that, as HPSB has that limitation of 1 year, they have stated that no, this
2 years.
3 years under consumer protection.
Challenge.
So they have
I don't want to give an opinion here.
that.
Challenge. If we will challenge. See, the approach has been, no, consumer is always, whoever comes is wrong. And that mean? We need to balance, weigh every matter on merits. Which says 1 year limitation plus 3 months if extended. Correct. Challenge it, it has to be tested. I am no more a judge. Wish I could have heard these matters. But you are right, this is a perennial problem, not today, has been happening. 1 year is not applicable to us, 2 years.
Under these provisions, you can file petition before the Madurai bench. Writ petition or original suit. You can file petition under Article original suit.
226 ல நீங்க எப்படி சார் எல்லாம் ஃபைல் பண்ணிடுவீங்க? பண்ணவே முடியும்.
original suit
226 ல நீங்க எப்படி சார் எல்லாம் ஃபைல் பண்ணிடுவீங்க? பண்ணவே முடியும். இப்போ மദ്രാஸ்
original suit மெட்ராஸ் தான் போறோம்.
மദ്രാஸ்க்கு தான் போனோம். நீங்களே ஆன்சர் கொடுத்தீங்க. அத மதுரையில ஃபர்ஸ்ட் query raise பண்ணோம் இல்லையா?
When we were discussing about the section 4 of Maritime Claims Act, you were explaining that the provision says any question on maritime claims and not just to hear and determine maritime claim. Can you elaborate further on that?
No, I am only reading from the section. I have not given any opinion. I have posed a query. I have posed a query to all of you. Therefore I said, you research, you write an article, benefit the fraternity. So it says, therefore I said, why not state any maritime claim? Why any question of maritime? Why are the words used, question of? Hence I said, you need to, that's how you read every section and question why. Why not like this? Then you will assess court better. Judges are dependent on you for help. Yes, one of the matter, that Alondra Rainbow piracy matter that I mentioned, there the ship, he mentioned about various jurisdictions, Liberian. The ship Alondra Rainbow was owned by Japanese company, flying Panamanian flag. 2 crew, master and marine, the chief engineer were Japanese. The remaining 14 were Filipino. She loaded a cargo of aluminum ingots in Kuala Tanjung in Indonesia for discharge at Miike in Japan. When she sets sail in the night, the master hears knocks. He opens, he finds pirates brandishing swords and pistols and weapons. They hijacked the ship. To cut the matter short, the message was, there is in Kuala Lumpur, International Maritime Bureau has got a PRC, Piracy Reporting Center. I'm telling you from my memory of a matter I worked in 2000, 26 years ago. So she was sailing, PRC sent messages, and a ship by the name Al Shuhada off Kerala coast said, we have seen a similar vessel, but the name is not Alondra Rainbow, it says Mega Rama. But with checking, they identified, and then the Indian Navy and Coast Guard chased the ship from Goa, Bombay, into the high seas. Dr. Santakumar mentioned about 12 nautical miles, territorial jurisdiction, contiguous zone, EZ. 350 nautical miles into the sea, they were intercepted. That ship was intercepted. Naval vessels, Godavari and Kaveri and all towed to Bombay. Okay? The Bombay Yellow Gate police station, which has jurisdiction in the port, took charge of the ship, everything. And then they realized, how will we exercise jurisdiction? Panamanian flag, Japanese owners, offense committed in the South China Sea. She is intercepted 350 nautical miles. Crew members, the pirates who were found were all Indonesian nationals. How does Bombay exercise jurisdiction? So they came to my senior, and I was sitting out, my senior was also Iyer, Venkatesan, senior advocate. I said, I was sitting, Colin, will you work pro bono in this matter? It's a lifetime, once in a lifetime matter I am getting an opportunity, I agreed. I would have spent about 500-600 hours on the matter and spent a lot of money for taxi fare to go to the court and come back. Including in the end, in IO, the investigating officer said, sir, I need 20 photocopies of this 350-page judgment of the sessions judge. Can you make it for me? I did even that for him. There, the issue came, how do we exercise jurisdiction? He mentioned about UNCLOS, United Nations Convention on Law of the Sea. India is a signatory, we have also ratified. Don't throw away old editions of AIR manual. We found a very old edition in my senior's office, and I found this 1849 Act. Admiralty Colonial Offences Act, 1849. It has just one section, which in short says, if a felon is caught in the high seas, I'm just giving you the gist, again from my memory, is caught in the high seas and brought within the colony, the courts of the colony will exercise jurisdiction as if the offense was committed within the colony in its jurisdiction. Use that, read with UNCLOS, we said you can exercise jurisdiction, court exercise jurisdiction. So, நம்ம இதில் சொல்லுவாங்க கேரளாவில் உருவஷி சாபம் உபகாரம்னு கேட்டிருக்கீங்களா? அர்ஜுனா spurned the advances of Urvashi. So Urvashi got very upset. She said, you will become a eunuch. So then he said, I am doing a penance. How can you curse me? She said, all right, 1 year at your option. Whenever you decide. That helped him in his Vanavasam time, 1 year incognito, when he became, what is her name? The name. He goes, Brihanala. So therefore, Urvashi's curse helped him. Padu Mari, either repeal pannatadu, engala help pandithu, country help pandithu, court help pandithu. அது ஏன் பண்ணினா ஏன் repeal பண்ணல? It is like telling whether I will grow bald tomorrow. No way we can answer. Anyway, but good point that you raised.
Because now that we have passed our Maritime Anti-Piracy Act, Maritime Anti-Piracy Act also was silent about
Correct. There are a lot of, therefore I said, you all should write on this. You are pointing out. I attended a conference in Seychelles on maritime piracy. And these points were all discussed. But I am a retired Chief Justice. What more can I do?
Thank you, sir.
Thank you.
For your
All the best. Yes, son.
Sir, I have two questions. I find the ambit of this subject, sir, please, covers mainly four pillars. That is, deals issues between people, between companies, between ship. I find the subject helping four people, like personally. Number one, issues between ship. Let's keep it like between two companies. And then if we treat it like two owners, then it is two people. And also when it comes to pollution and sinking of ship, I find this subject helping nature against individuals. So, like if you want to put in order, when I ask this subject is for, like can we place it first people and then nature and then companies, ship, trade, or is there a change in this order? When I ask is this subject for, then what's the first answer? For who?
Into the high seas. Dr. Santakumar mentioned about 12 nautical miles, territorial jurisdiction, contiguous zone, he said. 350 nautical miles into the sea, they were intercepted. That ship was intercepted. Naval vessels, Godavari and Kaveri and all towed to Bombay. Okay? The Bombay Yellow Gate police station, which has jurisdiction in the port, took charge of the ship, everything. And then they realized, how will we exercise jurisdiction? Panamanian flag, Japanese owners, offense committed in the South China Sea. She is intercepted 350 nautical miles. Crew members, the pirates who were found were all Indonesian nationals. How does Bombay exercise jurisdiction? So they came to my senior and I was sitting out, my senior was also Iyer, Venkatesan, senior advocate. So I said, I was sitting, call him, will you work pro bono in this matter? It's a lifetime, once in a lifetime matter I am getting an opportunity, I agreed. I spent I would have spent about 500-600 hours on the matter and spent a lot of money for taxi fare to go to the court and come back. Including in the end, in IO, the investigating officer said, sir, I need 20 photocopies of this 350-page judgment of the sessions judge. Can you make it for me? I did even that for him. There, the issue came, how do we exercise jurisdiction? He mentioned about UNCLOS, United Nations Convention on Law of the Sea. India is a signatory, we have also ratified. Don't throw away old editions of AIR manual. We found a very old edition in my senior's office and I found this 1849 Act. Admiralty Colonial Offences Act 1849. It has just one section, which in short says if a felon is caught in the high seas, I'm just giving you the gist, again from my memory, is caught in the high seas and brought within the colony, the courts of the colony will exercise jurisdiction as if the offense was committed within the colony in its jurisdiction. Use that, read with UNCLOS, we said you can exercise jurisdiction, court exercise jurisdiction. So, நம்ம இதில் சொல்லுவாங்க கேரளாவில் உருவஷி சாபம் உபகாரம்னு கேட்டிருக்கீங்களா? Arjuna spurned the advances of Urvashi. So Urvashi got very upset. She said, you will become a eunuch. So then he said, I am doing a penance. How can you curse me? She said, all right, 1 year at your option. Whenever you decide. That helped him in his Vanavasam time, 1 year incognito, when he became, what is the name? The name. He goes, Brihanala. Brihanala. So therefore, Urvashi's curse helped him. அது மாதிரி இதை ரிப்பீல் பண்ணாதது எங்களை ஹெல்ப் பண்ணித்தது, கண்ட்ரியை ஹெல்ப் பண்ணித்து, கோர்ட்டே ஹெல்ப் பண்ணித்து. அது ஏன் பண்ணினா, ஏன் ரிப்பீல் பண்ணல? It is like telling whether I'll grow bald tomorrow. No way we can answer. Anyway, but good point that you raised.
Because now that we have passed our Maritime Anti-Piracy Act, Maritime Anti-Piracy Act also was silent about
correct. There are a lot of, therefore I said, see, you all should write on this. You are pointing out. I attended a conference in Seychelles on maritime piracy. And these points were all discussed. But I am a retired Chief Justice, what more can I do? Yes, son?
Two questions. I find the ambit of this subject is covers mainly 4 pillars. That is, it deals issues between people, between companies, between ship. I find the subject helping 4 people, like personally. Number 1, issues between ship. Let's keep it like between 2 companies. And then if we treat it like 2 owners, then it is 2 people. Also, when it comes to pollution and sinking of ship, I find this subject helping nature against individuals. So, like, if you want to put in order, when I ask this subject is for, like, can we place it first people, and then nature, and then companies, ship, trade, or is there a change?
Any law frame is for the benefit of all stakeholders. It's up to you to put it in any order you want. Depends on who you represent. As a lawyer, you take the case of your client as utmost truth. Will defend. So if you are representing the Pollution Control Board or the state authorities, you will say, I am paramount. Owner will say, what paramount? This is for even my benefit, because there are provisions for them also for setting up a limitation fund. And you also have to prove another thing in this limitation fund. Under the 1954 convention, it was AFP, actual fault or privity. So the owner had an obligation, if he wanted to set up a limitation fund, he has to prove that the loss did not happen due to my actual fault or privity. Now, the burden is shifted to the other side to say, he intentionally, he knew this, etc., etc. But, so therefore, by default in every case, a owner can set up a limitation fund. But in that case, the fund amount has been increased substantially. முன்னாடி 100 ரூபாய் கொடுத்து எல்லாரும் சண்டை பிடிக்கும்பா. இப்போ the law has been changed, the burden has been shifted, so instead of 100 it is 500. So it depends how you whichever way, it doesn't really help anybody in this order, whatever it is. You go and argue your case, you say my client is correct, fine, the court will consider and decide the matter. What's your next question?
Sir, fishermen from Rameshwaram, Dhanushkodi, still every day their fingers are cut, boats are chopped, their job is doing armed. So my question is, we don't have fences over the ocean, so he doesn't know the limits. But
you don't know.
No, fisherman doesn't know. Right?
They will know. Are you talking? A man who's in the sea every day, certainly they know. What happens is, I'm not blaming anybody. I'm not blaming anybody. This is again speculation. It is possible that in certain situations the boat gets pushed away because sea is not flat like this. It has its own roughness, ups, lows, etc. Secondly, the man would not have found enough catch here because fish also keep moving. So chasing, he will go that side. Nobody is there. Chalo inga solringaleya police illa signal cut pannuna. அது மாதிரி அவன் அந்த பக்கம் போய் பண்றான், பாவம் மாட்டிக்கிறான். என்னது செய்ய?
That's my question.
So therefore what to do? There is no way you can fence. You are supposed to carry, and you think those fishermen don't know. They are much more intelligent than all of us put together. Because he knows his business, he knows his sea, he knows his livelihood. His GPS is here.
As you said, if he is blown inside, we can't blame fisherman, right?
And you have to prove, no? So therefore, these are all, you can't answer. These are all newspaper questions.
Solution for those fishermen from your
Sorry,
side.
nobody can solve it.
So now the specialist department are issuing compulsory GPs.
Correct.
So if they don't get that, they will not issue the licenses.
But then the next question will be, what happens to a man without license? He goes. So therefore, there is no end to any of these things. As a lawyer also, you can answer, அவன் கேஸ் போடுவோனா எனக்கு தெரியாதுப்பா போட்டா நான் டிஃபெண்ட் பண்றேன். That will be your answer. இல்லையா? நீ அவன் கேஸ் போட்டா இந்த பாயிண்ட்ஸ்ல நமக்கு கிரவுண்ட், I will get you a good success. But if that man comes up with some other googly, you never know. Then you will have to work on it. So the same thing. There is no straitjacket formula. There is no answer to it. I can only say I don't know. Good. That lady wanted to ask. That's the last question I am taking. Please.
இப்போ வந்து ஒரு கண்ட்ரிக்கு நம்ம இன்னொரு கண்ட்ரிக்கு போனா அந்த பாசிங் வந்து நம்ம பே பண்ணுவோமா? கண்ட்ரி நம்ம கண்ட்ரில இருந்து அதர் கண்ட்ரிஸ்க்கு போறோம்னா நம்ம பாசிங் ஃபெசிலிட்டி வந்து பே பண்ணுவோம்.
Everybody has to pay. It's like you using a toll.
If we paid the toll fee, the toll gate will obstruct to go, or otherwise then how we climb?
Madam, இப்போ நீங்க வந்து மதுரையில இருந்து சென்னைக்கு கார்ல போற, நீங்க டிரான்ஸ்போர்ட் பிசினஸ்னு வச்சுக்கோ, உங்களுக்கு தெரியணும் எவ்வளவு டோல் இருக்குன்னு. உங்க ஃப்ரேட் நீ சொல்ற 1000 ரூபாய் சொல்றத உங்களுக்கு கால்குலேட் பண்ணிருப்பீங்க. 3 டோல் இருக்கு, 40 ரூபாய் வீதம். 120, 880 rupees is my surplus which I am getting. You are bound to know. So the question of having to later recover, yes, if something unexpectedly happens, then you will exercise lien on the goods, saying this is the contract you had agreed, and therefore unless you pay, I will exercise lien on the cargo. But if you find out after giving delivery, Govinda, what else? All right? Yes. Thank you very much, everybody. Thank you very much, MBA. Thank you very much, Gujarat Maritime University, Dr. Shantakumar, Dr. Abhay Singh, and all those. Initially, frankly, even when Justice Satish Kumar mentioned, even I felt a little sad that felt that nobody is interested. But I found quite a few people coming in, but the better part is nobody left. Whether the credit goes to you or the speaker, or it is a combination, I would say. Thank you very much. And if ever you want to have any such seminars, talk to him. Of course, he will organize only on maritime. You can talk to Somayaji in Madras, in Chennai. He can also put you in touch with I'll give him also the Bombay Bar president and even the secretary's number now I'll give you. speak to them, and if they can organize, you can do it, but please ensure there is enough participation. Otherwise it becomes, even for those who are speaking, there should be interest, and that interest is based on your participation. But do a wonderful job. I enjoyed, I should say, my stay in Madurai, my stint, though very limited. And as I said in the beginning, many came later. Thank you for giving this opportunity to take leave of all of you. விடை பெற்று போகிறேன் நான் உங்கள்கிட்ட இருந்து.
Thank you, Lordship, for the wonderful lecture, and especially you touched all the areas, jurisdiction, ship arrest, all the aspects you have touched. We extend our heartfelt thanks. Now I request our advocate S. Chellapandyan to propose vote of thanks.
Very toughest job. இந்த டைட்டில் வந்து vote of thanks சொல்கிறது வந்து உண்மையிலேயே ரொம்ப ஒரு கஷ்டமான ஒரு விஷயம். Because everybody is tired, I think. So it's okay. I first of all thank MBA to have this program here, and our great sincere thanks to our beloved former Chief Justice of Madras High Court, Sriram sir. We are very much grateful to you, sir. This is a wonderful session, sir. We are having, it is a ignition point. This will go on, sir. Definitely we are having 4 bar associations here. So each one will take next level of this program, sir. So that we will assure you, sir. இது தொடர்ச்சியான ஒரு நிகழ்ச்சியாக இருக்கும். So I thank my guru, my life. நான் இன்னைக்கு இந்த இடத்துல இருக்கேன்னா காரணம் அது வந்து none other than Shantakumar sir. So he groomed me, and he gave me the life, I say like that. Because I thank you, sir, because he has given this opportunity to conduct this program at Madurai. நமக்கு இங்கே இந்த ஜூரிஸ்டிக்ஷன் இல்லைன்னா கூட இங்கே இருக்க ஸ்டூடெண்ட்ஸும் இங்கே இருக்க அட்வொகேட்ஸும் லாஸ்ட் டைம் வந்து இதே ப்ரோக்ராம் ஐ திங்க் வந்து we have conducted in Government Law College Madurai. So now we are conducting here the bar. So it will be a continuous program, not only in maritime law, in various aspects we can use him. என்னுடைய பணிவான வணக்கத்தையும் நன்றியும் நான் இந்த தருணத்தில் நான் சாந்தகுமார் சாருக்கு தெரிவித்துக் கொள்ள விரும்புகிறேன். And I thank the President of the MBA, Suresh sir, and Venkatesan sir, and all the office bearers of the MBA, and not less than the participants who attended. We tried lots to bring more participants, but today unfortunately we have some other events in the bar, some bar association. And I also convey my very heartfelt thank to our administrative judge, Sadish Kumar J, who has immediately given his consent to inaugurate this program. On behalf of the organizers, I thank him also, and I also thank ma'am, who has patiently waited for the entire program. I thank you very much, madam, for coming to Madurai. You have to visit again to Madurai to see Meenakshi, and I thank one and all. Thank you very much. We are having the dinner at the end. Please participate in the dinner. Thank you. Thank you very much. இதே மாதிரி நம்ம எல்லாம் நாலு at this point of time I request all the bar association try to bring the maritime jurisdiction here. This is the first step. We can use this seminar or workshop to bring that one all the bar association. You must வந்து இது வந்து ஒரு ஆப்பர்ச்சுனிட்டியாக எடுத்துட்டு இந்த மாதிரி யங்ஸ்டர்லாம் இங்கே நிறைய வந்திருக்கிறாங்க. இதை பார் அசோசியேஷன் தான் செய்யணும் முடியே, வேற யாரும் இந்த ஸ்டெப் முன்னெடுக்க முடியாது. And I also request Shantakumar sir, he is having so many contacts, and I assure that he will do something for this bench. Thank you, sir. Thank you very much.